ಸ್ನೇಹಿತರೆ, ಈ ದಿನ ಇದು 3ನೇ ಉಪನ್ಯಾಸ ನಮ್ಮ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ವಿಭಾಗದಲ್ಲಿ ನಡೆಯುತ್ತಿರುವಂಥದ್ದು. ಈಗ ಹೊಸ ಭಾರತೀಯ ನ್ಯಾಯ ಸಂಹಿತೆ, ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ ಮತ್ತು ಭಾರತೀಯ ನಾಗರಿಕ ಸುರಕ್ಷಾ ಸಂಹಿತೆ 2023ರ ಬಗ್ಗೆ ಉಪನ್ಯಾಸ ಮಾಡಲು ಮದ್ರಾಸ್ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಹಿರಿಯ ವಕೀಲರಾದಂಥ ಇ.ವಿ. ಚಂದ್ರು ಅವರು ಬಂದಿದ್ದಾರೆ. ಹಾರ್ಟ್ಲಿ ವೆಲ್ಕಮ್ ಟು ಇ.ವಿ. ಚಂದ್ರು. ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು, ಮಾನ್ಯ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳು ಮತ್ತು ಮುಖ್ಯ ಅತಿಥಿಗಳು ಸ್ಟೇಜ್ ಮೇಲೆ ಬರಬೇಕು ಅಂತ ಕೇಳ್ಕೊತೀನಿ. ಹಿರಿಯ ವಕೀಲರು, ಮದ್ರಾಸ್ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ವಕೀಲರಾದಂಥ ಇ.ವಿ. ಚಂದ್ರು ಅವರಿಗೆ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳಿಂದ ಗೌರವ ಸನ್ಮಾನ. Felicitation to the E.V. Chandru, the Senior Judge, High Court of Madras. ಸಾರಿ ಎಲ್ಲರಿಗೂ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಸ್ವಾಗತ. ಅದೇ ರೀತಿ ನಮ್ಮ ವಕೀಲರ ಸಂಘದ ಅಧ್ಯಕ್ಷರಿಗೂ ಕೂಡ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಸ್ವಾಗತವನ್ನು ಕೋರ್ತಾ, ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳು ಕೂಡ ಸ್ವಾಗತವನ್ನು ಕೋರ್ತಾ, ಮಾತಾಡ್ತೀರಿ. ಈಗ ತಮ್ಮನ್ನು ಉದ್ದೇಶಿಸಿ ಅಧ್ಯಕ್ಷರು ಒಂದೆರಡು ಮಾತುಗಳನ್ನಾಡಲಿದ್ದಾರೆ.
ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ವಿಭಾಗದ ಎಲ್ಲ ವಕೀಲ ಮಿತ್ರರಿಗೆ ನಮಸ್ಕಾರಗಳು. ಸ್ನೇಹಿತರೆ, ಕಳೆದ 3 ವಾರಗಳಿಂದ ಹೊಸ ಕಾನೂನು ಬರುವ ಮುಂಚೆ ಸತೀಶ್, ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿ ಜಡ್ಜ್, ಅವರ ಅದ್ಭುತವಾದ ಭಾಷಣವನ್ನು ನಾವು ಕೇಳಿದ್ವಿ. ವಿ ಹರ್ಡ್ ಶ್ರೀ ಸತೀಶ್, ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್. Satish introduced the speech by saying, there is one E.V. Chandru, advocate from Chennai, who can quote judgments from every section. I wish he is called here. Then and there, that day itself, we called E.V. Chandru sir. Our phone madi, sir, you should come. He was busy, so busy that we could get only today as his date. And I am so thankful to him that he accepted. Tomorrow, since we brought him here, tomorrow the judges of the High Court are hearing him for a whole morning session. The wonderful knowledge of E.V. Chandru sir is, ನಾನು ಇಂಗ್ಲೀಷ್ನಲ್ಲಿ ಮಾತಾಡ್ತೀನಿ ಯಾಕಂದರೆ ಅವ್ರಿಗೂ ಅರ್ಥ ಆಗಿ. The wonderful knowledge of E.V. Chandru sir is knowledge accumulated with lot of strain, effort, toil and sweat. He can run through all the sections and give judgments for every section, from 1 to 531 sections of Criminal Procedure Code and all sections of IPC. I think such a prowess, because of such a knowledge and prowess, he has been called to almost all judicial academies in India. He has lectured to judges all around India and lectured to lawyers all around India. Swami Vivekananda ಹೇಳ್ತಾರೆ, Swami Vivekananda says, the greatest seva you can do is feed the poor man, but a still greater seva you can do is give knowledge to those who are hungry for knowledge. And that is what Sri Chandru sir is doing. I thank him as part of the Advocates Association's drive to nurture youngsters. ನಾವು ಯಾವತ್ತೂ ಅಷ್ಟೇ ಕಿರಿಯ ವಕೀಲ ಬಂಧುಗಳನ್ನು ಮಿತ್ರರನ್ನು ಹುರಿದುಂಬಿಸಿ ಈ ನಮ್ಮ ಪ್ರೊಫೆಷನ್ಗೆ ಸ್ವಾಗತಿಸಿ ಅವರ ಮುಂದಿನ ಪೀಳಿಗೆಗೆ ಶಕ್ತಿಯುತ ವಕೀಲರನ್ನಾಗಿ ಮಾಡೋ ಒಂದು ಜವಾಬ್ದಾರಿ ವಕೀಲರ ಸಂಘಕ್ಕಿದೆ. ಆ ಜವಾಬ್ದಾರಿಯನ್ನು ನಾವು ನಿಭಾಯಿಸ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಐ ರಿಕ್ವೆಸ್ಟ್ ಶ್ರೀ ಚಂದ್ರು ಸರ್, I thank the Secretary of the Advocates Association for being here, Shri T.G. Ravi. Thank Shri Lingegowda, Vice President of the Advocates Association. I thank Shri Satish, Joint Secretary. I thank the Governing Council members and the staff of the Advocates Association. ಈ ಒಂದು ಸೆಷನ್ ಅವರು ಮ್ಯಾರಥಾನ್ ಸೆಷನ್ ಸುಮಾರು ಒಂದು 7 ಅವರ್ ತಗೊತಾರೆ, 6 ರಿಂದ 7 ಅವರ್. There will be a break between 2 o'clock to 2:30. And Chandru sir, we can decide what time he wants to give the break, and then we will reassemble at 2:30 and recommence the entire speech. And this is going live throughout Karnataka. I thank you very much, and now I request Shri Chandru sir to commence his speech.
Yes. ಇನ್ನೊಂದು ನೀರು ಅವ್ರು ಕೊಟ್ಬಿಟ್ಟು ಈ ಸರ್ ಕೊಡ್ಬೇಕಂತ.
Good morning, everybody. I am happy to see you all, and at the outset, with the blessings of my parents and my teacher, Mrs. Vrinda Mohan, an advocate of Pondicherry, I am in front of you. My heartful thanks to President Sir, Mr. Vivek Reddy, and because of his sincere efforts, I am here. My thanks also goes to the Deputy Director, Karnataka State Judicial Academy, Honorable Judge Satish Sir. My sincere thanks to the Honorable Secretary Ravi Sir and Lingegowda Sir. And we have also another one, Satish Sir, here. So, very nice morning. And my brother belongs to your state, my elder brother. He was here for 30 years from Tamil Nadu. So Karnataka was too loving, so he continues to stay here. He came as an engineer here. He has resided here for 30 years. So in that score, I have a due to do to you. I am indebted to Karnataka. So today, the Bar Association, the President and Secretary has told me to handle a session for all the 3 new criminal laws. We will try to do that today morning. And you all have books with you? 3 criminal laws? Yes. Because it is going to be a session around 5 to 6 hours, you can note down in the book and you can refer. And judgments, even if you miss some of the judgments, I will send all the judgments to Vivek Reddy sir. He will give it to you. Okay. The around 180 judgments are there, which I have spoken in Tamil Nadu State Judicial Academy for honorable judges for 3 days. Those judgments they have compiled and they have sent to me. That judgment I will give it. Suppose you are missing some judgments here, you can use that judgment also. Okay. Yes. So in all these 3 new laws, you all know that there were 3 laws which we call as what is that 3 old laws called? Major laws. Right? It is CRPC, IPC, then the third one, Evidence Act. So IPC is of the year 1860, CRPC 1861, then thereafter it becomes CRPC of 1898, then thereafter it is CRPC 1973. So originally CRPC was of the year 1861, 1898, then 1973. Right? IPC 1860, it remained as IPC of 1860. Evidence Act is of the year 1872. Excellent. Very good. So Evidence Act is of the year 1872. Now what has happened? These three laws were old and outdated, and it required frequent amendments in that. You also know about the amendment of Criminal Law Amendments 2013 and 2018. So instead of amending, and basically all these laws are British laws. It were given to us by the British people. So the Indian Parliament thought fit that these old laws should be repealed, and these laws contains many colonial provisions also. It contains the word king, the queen, the UK Parliament, the British Parliament, and so the Indian Parliament thought we will give a new law under new names. And the word Bharat is not a new word. Right? You take the Constitution of India, Article 1 to 5. What is Article 1 to 5? It speaks about union and its states. Right? Is it 1 to 4 or 1 to 5? 1 to 4. 5 to 11 speaks about citizens. Excellent. You are all very intelligent. I think a session is not required. Vivek Reddy sir has called me for no reason. You know everything. You are all very intelligent. And the first provision article says India, that is Bharat. So the original name of India is Bharat, and we are all accustomed of two words, Sakshi. Even in Tamil Nadu, no, we call Evidence Act as India Sakshiya Sattam, previously also. So we call witnesses in the court also Sakshi in Tamil Nadu. So India Sakshiya Sattam, Sakshiya is not a new name. It is referring to witness. Then any man who stands in a criminal court wants nyaya, that is justice. Right? It can be either in the way of compensation, it can be either in the way of putting the accused in the jail. So the Parliament thought that Indian Penal Code can be captioned as India Nyaya, Bharatiya Nyaya. Yes, very nice. So Penal Code, the purpose of Penal Code should not only to punish. It should also reform. See, whenever we are studying law college, my law college student, dear children who are sitting there in the last, in our criminology paper, we will have various theories of criminology, right? Various theories of criminal law. They will say reformation, retribution, deterrent, then 4 schools of criminal laws. Deterrent, retribution, reformation, then what else? There are 4 things, no? What is the 4th? You remember and tell me. What is one? Restoration. Yes, just take it and tell me. Okay. So now the Parliament thought penal law can be termed as Nyaya Sanhita. Then Evidence Act can be called as Sakshya Adhiniyam. Then coming to Criminal Procedure Code, they thought fit to rename it as Bharatiya Naharik. What is Naharik? Nahar is town or city. Naharik, citizens. What is Suraksha? Protection. Then Sanhita, code or act or law. Okay. So this is the background, right? To justify all these new criminal laws. Now I am happy that I can come after 4 to 5 months. If I come to Bangalore, I can come from Chennai within a time of 2.5 hours. They are going to put an express avenue. I think it is almost finished. By December. Yes. By December, if your President Reddy sir calls me, I will come by car. It will take only 2.5 hours. Right? Previously, no, from Madras to Bangalore, it takes around 9 hours. Some 10 years back, it took 12 hours. Right? We were all accustomed to small roads. Then the small village roads become state highway. Then state highways have become national highways. National highways have become express avenues. So change is inevitable. Like that, the new laws are like express avenues. The parliament thought that the old laws, because of the old laws, no time frames were there, no accountability, no responsibility, no transparency. So it was all repaired properly and they have presented a new law. So let us not get scared on the new law. That is one request which I want to make to you. We were all scared for everything. When electricity was invented and it was supplied to all the houses, they thought some demon or devil is in the wires. Right? Leave alone electricity. When trains were invented and put into the tracks, people thought some ghost is driving because all that smoke is coming, no, steams and smokes are coming, they thought it is the work of the devil. Even forget all this electricity and train. Think about the gas cylinders. 25-30 years back when gas cylinders came, there were times when we will not bring it inside the house because we scared that it will burst at any time. We were keeping it in the which place? Outside the house. So any new thing, it will give a scary thought. Take about a new wife. New wife, NEWWIFE. If a new wife enters inside the house, what will happen? The old mother-in-law, what she will think? You are all married? Not married. How many of you are not married? Majority. Oh, so many of you are married. When a new girl comes inside the house after marriage, there is some fear, some apprehension. So for any new thing, it is the human genetics that we will resist it unless and until we will accommodate and adapt with that. Then thereafter sometimes you cannot be with your wife. You cannot be with your wife. Or you cannot remain without your wife. Two things. It is all how she adapts with the family. Now we will come to firstly we will finish this Sakshya Adhiniyam because it is a small law. Some minor amendments were made. We will come first to the erstwhile Indian Evidence Act, which is the present Bharatiya Sakshya Adhiniyam. Okay, or it is called BSA. So we will come first to Bharatiya Sakshya Adhiniyam. We will finish it very short. Then we will come to Bharatiya Nyaya Sanhita. Then Bharatiya Nagarik Suraksha Sanhita will take a long time because it has got 531 provisions and so many amendments are there. Right? We will come to Bharatiya Sakshya Adhiniyam. You can take BSA book with you. Okay. Previously, how many sections it has got? The old Indian Evidence Act, how many provisions? 167. Now how many provisions are there? 170. BSA contains 170 sections, one schedule. If you have a book, you can mark or you can write. It contains 170 sections, one schedule, two parts in the schedule, part A, part B. Okay. This part A and part B governs a certificate called as the 65B certificate of Indian Evidence Act. 65B certificate, B for ball. Now it is 63 4C, 63 subsection 4 subsection C. Okay. Our Vivek Reddy sir circulated my photo in so many groups, and we were all thinking that Chandru was a very handsome person. When you saw Chandru physically, you were all disappointed because photos always shows a better image. See, so many, I enrolled as an advocate in 1997. So I am in advocacy around 26 years. So many women has complained or so many men has complained when they came for divorce that the photo and the original person differed. See, before marriage, no, there are marriage brokers. They will come with beautiful photos. And we will see the photos and say, yes, this girl is very handsome. And the moment you go to the marriage hall, you will see a different girl. Why? Who has done the wrong? Photographer or the DTP person? Photographer, now the photographer takes the picture as it is. The same Chandru. Right? If you ask him to change Chandru as Amitabh Bachchan, Shah Rukh Khan or Kamal Haasan or your Chiranjeevi, then he will do that. How it is all possible? How it is all possible? These digital documents contains the information as 1 and 0, binary numbers. These ones and zeros can be manipulated without getting detected. Now we are talking about 65B certificate, which is presently 63(4)C. Why the court is insisting for a certificate means electronic records, digital records are capable of manipulation. You can show a cat as a tiger as a rat. Because of this manipulation, court is insisting for a certificate from a person who takes a printout and give. I will tell you like that. I will explain you with more ease. See, this is my cell phone, right? Photographer is sitting in front of me. I am taking a photo out of this electronic device, right? Now, I give the whole device to the court. This is called as what evidence? Primary or secondary? Primary. Louder? Primary. Yes. My dear students behind, do you follow? I take photo of a person through my phone. Now this is an electronic device. If this device itself handed over to the court, it becomes a primary evidence. So what is not required? Certificate is not required because the device contains the document in that. I pull out from this device, I take an outlet of that, or I take an outlet from a computer, from a laptop. The moment I pull something out of that, it becomes a excellent. It becomes a secondary. So, now because Chandru is the owner of the phone, court is expecting you certify that what is pulled out is equivalent to what is in the device. You understand, my dear? Yes. There are so many young people. So whenever I am addressing my dear, it is all for my dear children and for my dear brothers and sisters. Okay? Don't take it otherwise. Can I call you as dear? Yes. Only one person is dear.
People call darling also.
No, I am not calling anybody as darling.
No, dear is also okay.
Okay. Yes, my dear? Yes. So, any person who is owning, possessing, managing, administrating an electronic device and takes something out of that, takes a printout, that person is mandated under law to give a certificate with regard to its accuracy, that it is not manipulated. So, from today, please don't think that 65B is something from heaven. It is an authorization, it is a guarantee that the person who is owning, managing, administering or possessing an electronic device gives a guarantee to the court, yes, this was with me This is in a working condition. It is not interfered by anybody else. Who is the guarantee? I am the guarantee. So that guarantee certificate he gives. Previously, under Indian Evidence Act, so many affidavits under 65B were given in different modules. There is no standard format. Now go to 170, section 170 of Sakshiyas Adhiniyam. You see that schedule and 2 certificates. You have got it. Yes. Part A to be filled by the party. So I am referring to section 170. Thereafter 170 you see the schedule. In schedule there are 2 certificates. One is part A, another is part B. All got it? Yes. In part A it is stated that to be filled by the party. I will tell you an example, right? My wife takes my cell phone. I am in the bathroom, right? What is the time for wives to check the phone of the husband? You all seems to be very good and innocent. If a partner is suspecting you, through how you will be caught? What is the first yama for you? What is the yama for you? Cell phone. By reading a cell phone, your character can be seen, assessed. You take any man, I will tell you a technique. You take any man's cell phone like this. Any man's cell phone, right? You open the cell phone. You go to Google. And what appears? What will appear? What are the areas you are interested will be kept uploaded. If you take my cell phone, you can see so many judgments of so many high courts. You take any man's cell phone, go to Google, open it. If you find many judgments, that man is interested in judgments. If you find the eateries, you will see that man very obese and eating always. If you see so many cinema messages, that man is interested in cinemas. Like that, people who are in suspicion, partners, without the knowledge of the other person, they will take the phone, one thing. And every man, however he is intelligent, he will leave some trace. Right? And the person searching it will take a photograph or load it to his own phone, go to the family court and show that this man is in a relationship with another one person, so I want a divorce from this person, right? And these electronic records, any person who gives evidence through electronic records is duty bound to give a certificate because he is not producing the original. He will be producing only a printout or an outlet from an electronic record. Now law says, 63 says, read with 170, schedule says, during producing of that certificate, you should also give the hash value, HASH value. Okay, what is this hash value? Anybody here? Hash value. Nobody. See, a mandate is there to reveal the hash value. You go to the certificate once again, part A, I so and so, then come down, next para, the digital device, then come down, I state that the hash value of the electronic or digital record is obtained through the following algorithms. What is the hash value is? This is the electronic record, right? This electronic record, imagine this for a moment, that a pen drive I am giving, or a disk I am giving, or a CD I am giving, I should subject it with these algorithms through the software, and a hash value will come out of that. What is that hash value is? It is like a seal, S-E-A-L. Seal means if you put the hash value and give it to the court, if somebody else makes any manipulations in future, hash value will change. You understand, my dear? You take an electronic record, you get its hash value, you can either do it or you should go to an expert, and with that electronic record, if you give a hash value also along with that, court will immediately verify and court will also note that the hash value is proper. Suppose even if a full stop or comma is made in that, hash value change. So, hash value is like a seal or guarantee that on the data of producing this electronic record, I have produced it, I have given it in this content. Any manipulation in the content, what will change? Hash value will change. So, this is an innovative thing which the Parliament has done, such that any person who relies on electronic record should produce a certificate called as a certificate by the party and also a certificate called as an export certificate. So from whom you should obtain it is IT Act. You all know that there is an act called as IT Act. IT Act refers section 79 capital A. Every state government shall notify experts called as electronic experts. We have got experts, no, handwriting expert, fingerprint expert, like that. 79 capital A mandates that every state government will notify an expert in electronic field called as electronic experts. Those experts can also deal with all this. Otherwise, it is a simple software. You can take the advice of some electronic field people, IT field people, and you yourself can give this hash value to the court. So this is called as hash value. What is the certificate we are talking about? 63 certificate. Previously 65 capital B. Okay. Now coming to the next thing. Why I am dealing it in elaborate is BNSS, that is our CRPC, has also shifted from papers to paperless. Now this is a period, transitional period. Previously our elders were writing in papers or leaves. In older periods, leaves. Prior to that, you go to temple, no? Stones. Right? During my schoolings, we used to give love letters in paper. Now anybody is giving love letter in paper? My dear children on the behind, are you writing letters now? What are we doing? We are sending it in WhatsApp, electronic form. Private messages they don't send in social media. They will send in WhatsApp, and there are so many things which I am not aware of. Because I am an old man, I am not in the habit of loving now. Right? So now Parliament also thinks that all agency, including the court, should transform from paper to paperless court. Okay. Now our President and Secretary sir said it is all live transmission in Facebook and YouTube. See, these photographers, these experts are recording it in their system, in their electronic device. This will be connected to some hardware in their office. Now this is also getting transmitted in Facebook and YouTube. Now law says, section 61 of Bharatiya Sakshi Adhiniyam says, 61 says, all these transmissions done simultaneously are dash evidence, primary or secondary? Please tell me. Now what is happening? They are transmitting straight in Facebook. And these Facebook, somebody else will be recording in their device. They will also record in their iCloud or whatever cloud it is. They are also transmitting to their office. All these transmissions are made at same point of time simultaneously. They are all called what evidence? Yes, excellent. These are all, now section 61 says, all these recordings which are done simultaneously in multiple devices are primary. We will imagine like this. Chandru loves somebody secretly, makes a phone call secretly and goes in video, right? Talks with that girl. And thinking that Chandru is erasing all that in Chandru's cell phone, that girl goes and gives a complaint. Police people comes, take my cell phone. Chandru is not aware that the erased version will go to my cell phone. If I erase also, where it will go? In my device, where it will go? Bin, trash. If the investigating agency comes and takes the information from the trash or the bin, that is also what evidence? Primary evidence. Because it is in my device and that got settled the moment it is recorded. So now section 61 has made many electronic evidence as what evidence? Primary evidence. Previously we were thinking that primary evidence, electronic evidence has a little scope. Now Parliament has expanded the scope. So please read section 61 of Bharatiya Sakshi Adhiniyam, which has expanded the scope of primary evidence, because from 1/7, so many evidence in court will be given only in what form? What form? Electronic form. Excellent. It will be given only in electronic form. So we should first understand that these electronic forms, whether it is primary or it is secondary, right? If it is taken as an outlet, then it is secondary. If original itself is given, primary. If it is transmitted at the same point of time simultaneously in various devices, excellent. That's all. We need not break our head much in this. Okay, my dear, understood? Yes. So, two judgments you should read. To understand more about electronic evidence, you take a printout and read it many times. One is Arjun Panditrao Kotkar versus Kailash Kishan Rao Gorantil. Arjun Panditrao Kotkar versus Kailash Kishan Rao Gorantil, full bench, 2020 Supreme Court. It says 65B certificate is what? Directory or mandatory? I told you, no? 65B is mandatory. Be loud. 65B is mandatory because digital records are capable of manipulating. Excellent. Give a big hand to him. This is not a big hand of Kannadikas. The big hand should be a big hand. Excellent. Super. 65B is mandatory because digital records are capable of manipulation. Right? That is the reason 65B is mandatory. Now 65B is presently 63. Excellent. What is the judgment? Arjun Panditrao Kotkar, which court? Supreme Court. In full bench. In that para 63, note that in that para 63 says questions with regard to transmitting, receiving, storing, how it has to be received, how it should be transmitted, how it has to be stored, all these will be governed by November 2018 rules. You read para 63 in that, you will understand how you should receive electronic records, how you should transmit, how you should store, how courts should handle that. All this is spoken of in para 63. They refer to a report which is called as Electronic Committee Report of Honorable Chief Justices of India. Supreme Court has convened a meeting for the electronic committee of the Chief Justices of all High Court, and a report was given in November 2018 by Honorable Justice, His Lordship Justice Rajesh Bindal. He is the present Supreme Court judge. Then he was either the judge of the Himachal Pradesh and thereafter the Jammu Kashmir. Right? So this is what is this thing. And when this certificate has to be filed. We were talking about 65B. Now it is 63. When it should be filed? Should it be filed while filing the record itself, while filing the electronic document itself, or it should be filed before concluding the trial? When? Suppose out of ignorance, a client files a pen drive without giving certificate. Now because of is it a great sin? Because of that it should be thrown out. Arjun Pandit Rao Kotkar says it can be filed at any time before conclusion of trial. You understand, my dear?
Curable defect.
Ji?
Curable defect.
Yes. It is a curable defect. Excellent. 65B certificate can be filed at any time before conclusion of trial. Now, what is conclusion of trial? When a trial gets concluded? This is the next question. We will first come to a civil case. In a civil case, when the trial gets concluded?
When the matter is reserved for judgment.
My dear friend says when a matter is reserved for judgment. That is, plaintiff side finished, closed, defendant side closed, arguments heard, and judge says it is reserved for judgment. We generally think, we believe that trial is over when it is reserved for judgment. Supreme Court in Sukhpal Singh Kaira versus State of Punjab. Sukhpal, S-U-K-H, P-A-L, Sukhpal Singh Kaira, K-H-A-I-R-A, Sukhpal Singh Kaira versus State of Punjab, 2020, Constitutional Bench, 5 judges. Says a civil trial gets concluded on the date of judgment. I am repeating, a civil trial gets concluded on the date of judgment. So when can we give 65B certificate? Even after? Even if it is reserved for judgment, Sukhpal Singh Kaira says trial is not terminated. You understand, my dear? Sukhpal Singh Kaira, 5 judges bench, constitutional bench says trial gets concluded in a civil case on the date of, you should say, civil judgment contains another part also. A civil judgment contains 2 parts. What are they? Judgment and decree. Okay. I will ask some junior advocates. What is your name, my dear? Pinakini. Okay. When did you get enrolled? 2023. Have you ever been to copy section? Whether the decree will be ready? Civil lawyers, whenever we apply for a judgment and decree, which will not be ready? Decree will not be ready. What the copying section will say? Judgment is ready, decree is not at type. So, a judgment is work of the judge. Out of the judgment, decree is taken out and typed by a decree clerk. Supreme Court says, listen very carefully. Supreme Court says a trial gets concluded in a civil trial by the pronouncement of judgment and not by pronouncement of decree, because decree is not a work which involves what mind? Judicial mind. So Supreme Court says civil case trial gets concluded on pronouncement of judgment. We will come to criminal case now. Chandru is facing a trial. Court says Chandru is acquitted of the charge. Now whether the trial is concluded? Yes. In a case of acquittal, trial gets concluded in a criminal case. Jot it down, in a criminal case, trial gets concluded on the date of acquittal, point 1. Point 2. In a criminal case, trial gets concluded on the date of acquittal. If it is an acquittal judgment. If it is a conviction, when trial gets concluded?
After sentence.
Excellent. Give him a big clap. I want a big clap. What is your name, my dear? Shankar. Beautiful. See, criminal judgment contains two parts. What are they? Conviction and sentencing. Sentencing also requires what? Judicial mind. You know that. Sentencing, whether it is made by the decree clerk, sentencing is pronounced by the judge. So, Supal Singh Kera Constitutional Bench says, a criminal trial gets terminated on the date of sentencing. Why we came to this? Why I said about termination of trial? Excellent. Because Arjun Pandit Rao Kotkar says a 65B certificate can be given to the court before termination of trial. That is, even if it is reserved for judgment, you have a valid reason. What is important? You have a valid reason that this reason has prevented me from not furnishing the certificate. Evidence is already inside. If this certificate is not given, that evidence will not be taken into account. It will cause prejudice to me, and it is the duty of the court to convince with this. Okay, this is one important judgment regarding Bharatiya Sakshya Adhinayam also. Second question. Judgments which were given by Supreme Court under Evidence Act, Indian Evidence Act, is it applicable for Bharatiya Sakshya Adhinayam?
There are Dhara material provisions.
Excellent. If the provisions are same, then it is applicable. See, now Supreme Court is following Privy Council judgments. You understand, my dear? When Supreme Court can follow Privy Council judgments before 1947, our Supreme Court judgment, because of change of law, you cannot say this is not applicable. However, I will tell one example. Previously, you cannot handcuff a person without court's permission. Now, section 43 subsection 3 of BNSS says, 43 subsection 3 of BNSS, Bharatiya Nagarik Suraksha Sanhita says, policeman may, taking into consideration the gravity and nature of offence, he can himself, while arresting or producing before the court, he can use handcuff. But Prem Shankar Shukla judgment was there, Citizen for Democracy State of Assam was there, Sunil Batra's judgment was there. All these judgments says policemen have no right for handcuffing. Now there is a change in law. Now those judgments are not applicable, irrelevant. My endeavor to impress upon you is all the Supreme Court judgments given under CRPC, IPC, evidence are applicable for the present three new laws if those provisions are not changed or altered. You understand, my dear? So all the judgments of the Supreme Court are applicable. The only bar is if there is a change in the provision, if there is a change in the intention of the legislature, then it cannot be done. Okay, second thing. There was a dispute in the High Court, in the Supreme Court. What has happened is, in the judgment, I think you will be knowing about one judgment. Gopala Krishnan alias Dilip versus State of Kerala. Gopala Krishnan alias Dilip versus State of Kerala, 2019 Supreme Court. Right? Regarding electronic evidence. Because these two judgments are major judgments which you all should definitely take a printout and thoroughly read it. This this judgment, Gopalakrishna as Dilip is the state of Kerala, 2019, Supreme Court, I will tell you the fact. One lady goes to the court, says that, gives a record by way of a pen drive, says that this man has made some nonsense with me and these are all the obscene contents. He made me to behave in an untoward this thing with me, and this, what is the evidence? She produces a pen drive with regard to the accusations as against the man. Now, charges were framed. At the time of giving free copies, this man is insisting for the pen drive. Question before the court is, prosecution is telling that pen drive is not a document, it is a material object. Accused is telling it is a document because she is telling that pen drive contains vital documents. Please listen carefully. The lady side prosecution is telling pen drive is a material object, so we will not give. Accused is telling, I want to see what is inside. For me it is a document. This went up to Supreme Court. Supreme Court said both of you are right. How? Pen drive is a material object. Contents in the pen drive are documents. So, Supreme Court said prosecution is also right, defense is also right. You give the contents which are in the pen drive to the accused. Now, this lady says there are obscene photographs in that. Can you give the obscene photograph to the accused? Cannot. What he will do? Her privacy, she is telling that there are nude photos and naked photos. It cannot be given to him. What? It will do more damage to the girl. Now court says a via media has to be worked out. What is the via media? It is the question. See, all this will come in all the cases for you because everything is in electronic mode from 1/7/2024. Court said, if it contains nude photos, obscene photos or things involving privacy, it should not be given to the accused. However, the accused advocate and an expert can have a look into that because we said there are possibilities of manipulation. Now the expert will see whether there is manipulation. Point one. The accused will now come and say, sir, these are all edited. She is not showing the full photos. It is she who has called me for this act. She has disconnected everything. She has erased one part and she has put the second part. So now Dileepan says, how an electronic document, copies of that should be given to the other side. Come to the next thing. Supreme Court says, whenever there are electronic records, copies has to be given not as normal copies, cloned copies, CLONED. In Dileepan's case, Dileepan alias Gopalakrishnan case, Supreme Court said the other side is entitled for cloned copies, CLONED. What is a cloned copy, my dear? What is a cloned copy? See, I am leaving Bangalore tomorrow. Vivek Reddy sir is bringing a man on Monday. He is like me. What he will say? He is a cloned. So what do you mean by cloned? Mirror, replica. So any electronic document copy should not be given like a Xerox copy. It should be given the cloned copy, means the accused or the expert for the accused counsel or the counsel should understand from that cloned copy what is the manipulation, what is the duplication, what is the original content. So cloned copy is any alteration made in the original should also reflect in the copies. So whenever you receive an electronic document from the other side, what you should insist? Cloned copy. Why? Without a cloned copy you cannot understand alterations. So two judgments we have seen. One is Arjun Pandit Rao Kochkar. What for? Certificates are mandatory. What is the second judgment which I have seen? What is the proposition? Copies, electronic documents copy should be given as a cloned copy. If it is infringing the privacy, whether accused should be given a copy? No. But accused will have a right to inspect. Whether he alone will inspect? Advocate, then expert. Now you are clear on these two. Will you have any doubt in certificates? Yes, my dear. You sit and ask.
Sir, if at all I obtained a copy of a CCTV footage from a public authority, say it is a traffic police, so they give me printout of the photos. So am I still, should I still insist on 65p certificate from the issuing authority?
Yes. That is the reason I used 4 words. Who owns, who possesses, who manages, who administers. Unless the CCTV's hard disk is moved to the court, any copy taken out of that, still 63, it is a protection for the court. It is a protection for the person. Right? Unless the original source is given, then you can still insist for a 63.
Irrespective of who the issuing authority
Yes.
although it is a public authority.
Yes. Law doesn't make any difference in that. Okay? Yes. Now we will come to other sections. So we have finished section 61, 63, 170 and schedule which contains 2 certificates. Okay? Yes. We will come to section 1. Yes. What is the alteration made in section 1? Previously it was called as the Indian Evidence Act. Now it is called as Bharatiya Sakshi Adhiniyam 2023. Right? See, previously it was not applicable for court martials. What are court martials, my dear? Military court. There is an act called as Indian Army Act, Indian Navy Act, Indian Air Force Act. And there is a department in Indian military called as JAG, J-A-G, Judges Advocate General. Like our honorable judges, these Indian Navy, Indian Air and Indian military contains people who are all called as judges. They will try people who are erring under those laws. Previously, the Indian Evidence Act is not applicable for Indian court martials. Now it is applicable. This is one major change in section 1. Then, in Indian Evidence Act, section 3 had the definition portion. Now section 2 contains the definition. Okay, so mark section 2. Then come to section 2, subsection 1D, document. What was included? Major inclusion, electronic and see the last lines of document 2 subsection D, 2 subsection 1 small d. Document means and includes electronic and digital records. Note one thing that neither of the 3 laws have not explained what are digital records. They have defined only electronic records. Digital records were not explained in all the 3 laws. Underline that. Okay. This is one important thing. In Indian Evidence Act, how do they define a document? Any inscription on any matter is a document. Right? You go to a park, you go to any park, old trees will be there. Right? In every tree there will be a heart shape and an arrow in the heart. And some fool's name will be there. That is the contribution of us to the park. Have you seen? You go to any park, old park, huge trees, 500, 600 years. What he will do? He will take a stone, he will make a heart, put an arrow, and he will write X versus Y. Is this a document? Is this a document? Yes. Why? Any inscription made on any surface is a document. Now, what is included is any electronic or any digital record is also a document. Okay, this is one important provision in section 2. Then, coming to section 4. Previously it was section 6 of Indian Evidence Act. Jot it down. The present 4 is equivalent to section 6. What present 4 says? Facts which, though not in issue, are so connected with the fact in issue or a relevant fact as to form part of the same transaction or relevant whether they occurred at the same time and place or at different times and places. Now they have included in the provision of res gestae. What is res gestae, my dear? There are two types of evidence. One is direct evidence. Another is res gestae evidence. See, res gestae evidence is different. Hearsay evidence is different. Direct evidence is different. Right? What is direct evidence? Chandru is standing here talking something. Right? Now Shankar is seeing that. Shankar is coming and pulling my hair and the coat and tearing it. Right? I am running out of the hall and shouting. See, you are all sitting. Shankar pulls my hair and plucks few hairs of mine, tears the coat of mine, and I run out of the court, shouting that Shankar is beating me, Shankar is biting me, which was heard by the policeman who is standing outside the court. The policeman has not seen Shankar doing anything on me. Now Chandru, who is uttering something in connection with the transaction which is taking place here, that policeman and all the onlookers on the veranda, they are all called as res gestae evidence. Res gestae means section 4 of BSA, which is equivalent to section 6 of IEA. Res gestae means things connected with the fact in issue. What is the fact in issue in the court? Tomorrow, whether Shankar has assaulted Chandru is the fact in issue. Fact to be tried by the court. What is the fact connected to the fact in issue is things said and done in the course of same transaction. What is that? Shankar is driving me, he is following me, shouting. I am also shouting and I am also going. But the witnesses who will speak of something which is connected with the fact in issue, which are closely related to the fact in issue, are called res gestae witness. Not only to fact in issue, but also to relevant fact to the fact in issue. This is one important change. What is 22? It says confession caused by inducement, threat, coercion or promise. This section 22 previously in Evidence Act had only 3 words: inducement, threat, promise. Now one word is included which is called as coercion. What is the difference? What is the word coercion means? The word coercion is not explained in the new act. Please refer Indian Contract Act to understand what is coercion. So one word coercion is also added in section 22. Okay, this is also another one thing, one new addition. Then this section 23 is a combination of, please jot it down, section 23 of BSA is a combined version of 25, 26, 27 of IEA. Previously 25. What is 25? Confession given to police shall not be used as against him. What is 26? Confession given to police in police custody in the presence of magistrate is admissible. What is section 27? Statement leading to discovery of a fact is admissible. Now section 23 is a consolidation of section 25, 26 and 27 of Indian Evidence Act. You understand? It is consolidated as one section, 23. Then come to section 24. Section 24. I will read section 24 and the explanation. Please come to 24 of the Bharatiya Sakshi Adhiniyam. Consideration of proved confession affecting person making it and others jointly under trial for same offence. Underline the word jointly under trial. Come to explanation. What explanation says? What explanation says? A trial or a trial of more persons than one held in the absence of the accused who has absconded or who fails to comply with the proclamation under section 84 of BNSS 2023 shall be deemed to be a joint trial for the purpose of this section. I will tell you one thing now. Underline the word in section 24 as these words jointly under trial for same offence. Now, in this, they have spoken of something called as proclamation. To understand what is this proclamation, you please jot down. We should read. When I am taking BNSS, I will tell you. Now you jot down 4 to 5 sections. To understand proclamation of offenders under BNSS, you put a topic. To understand what is proclamation of offender under BNSS, you should jot down section 34, subsection 2, Roman 2 of BNSS. 34, subsection 2, Roman 2. It explains who is a proclaimed offender. 34, subsection 2, Roman 2 of BNSS, who is a proclaimed offender. Then 84 of BNSS. What are the steps to follow to proclaim a person as a proclaimed offender? Section 84. Steps to be followed by court to proclaim a person as proclaimed offender, section 84. 86 and 107 of BNSS. 86 and section 107 of BNSS deals with attachment of the proceeds of crime. 86 and 107 of BNSS speaks of attachment of a proceeds of crime of a proclaimed offender. Section 355 of BNSS speaks about absconding accused. 355 of BNSS speaks about absconding accused. 356 of BNSS speaks about proclaimed offender. I will tell in short what is proclaimed offender, right? Proclaimed offender, now section 34 says of BNSS says, proclaimed offender is a person on whom an allegation of a criminal more than 10 years is willfully absconding. A person who is charged for an offence for which the punishment will be 10 years or more will be absconding after receiving summons also. Previously, what will happen if a person is absconding from the court? He will be declared as a proclaimed offender. By the time, what will happen to the witnesses? Whether witnesses will be alive? No. They will not be before this court for trial. They will be witnesses will be facing trial before the different court. Right? Now this proclaimed offender will come, he will say, I want to examine the witness. Witnesses will be dead and gone. Right? They will take a stand. This is a split proceedings. We were 3 in number. 2 people, trial went on. You used a confession which were given. That confession you should not use now, because confessions should be used only in a joint trial. That was the old law. Right? Now what has happened? A deemed fiction of joint trial was made under BNSS, and correspondingly section 24 explanation 2 also says, a person who comes in a later point of trial by way of proclamation of offender or by way of absconding also cannot take a defense that a confession should not be used as a subsequent trial, because law now says, because you are willfully evading a trial, you cannot take a defense that the subsequent trial is not a joint trial and confession of a co-accused should not be used. So this is one progressive step taken, and section 356 of BNSS says, if any person is proclaimed as a proclaimed offender, ex parte trial, ex parte inquiry, ex parte judgment will also be pronounced in his absence. It is almost like it has become like a civil trial. What will we do in a civil trial? If a defendant doesn't come, what we will do? Ex parte. Like that, now law says, a man who has no respect for a criminal trial, we will proclaim him absent, set ex parte in every inquiry, every trial, and judgment also will be pronounced. But he was given 3 years time to come to the court and give a valid reason. If the court feels that the reason is valid, then the ex parte will be set aside. Okay. So section 24 of BSA should be read along with section 138 of BSA and all the provisions of BNSS which I have referred. What is 138? 138 is pari materia with 133 of Indian Evidence Act. BSA 138. Please come to 138 of BSA. It is accomplice evidence. 138. This is pari materia with section 133 of Indian Evidence Act. Okay. Now what is the change made in 138? Now 138 says, an accomplice shall be a competent witness against a person, and the conviction is not illegal if it proceeds upon the corroborated testimony of an accomplice. I am repeating, 138 mandates for corroboration for a conviction. Please write near 138. Now 138 of BSA requires a corroborated version, unlike section 133 of Indian Evidence Act. This is one advantage of the accused for the right. A man commits a murder. After committing murder, if he doesn't surrender, he needs an antecedent. Can police compel you like that? Why? Can police compel you like that? Why? Where is the protection? Where is the protection? Come to 132 of BSA. Section 132, Bharatiya Sakshi Adhiniyam. What does it say? No advocate shall at any time be permitted, unless with his client's express consent, to disclose any communication made to him in the course and for the purpose of his service as an advocate by or on behalf of his client, or to state the content or condition of any document with which he has become acquainted in the course and for the purpose of his professional service, or to disclose any advice given by him to his client in the course and for the purpose of such service. So section 132 is the protection for all the advocates, which says no advocate shall be compelled to disclose the communications made between the advocate and the client. I will ask another one question. Tomorrow A is going to make a murder, commit a murder. Can he come to me today and ask for a opinion, guidance? Yes or no? Law college students. One man wants to commit a murder tomorrow. Can he fix an appointment with me today and ask him, sir, whether I should fire him or whether I should kill him with a sword? Is there a professional communication? Is it a professional communication? If I give an advice, what does it mean? Is it abetting or conspiracy? Or both? Both. So, professional communications are privileged communications which are protected if you have an advocate and client relationship. After murder only he becomes a client of you. Not before murder. Before murder, if you give an opinion, you will become a accused, accomplice. Right? So don't give any opinion like that. You tell him that, sir, after committing that you come to me. Okay. Can you advise like that? Then also you are duty bound to report, because you are aware that that person is going to commit a cognizable offence. You should be very, very careful. Now you come to section 131. What is 131? Information as to commission of offences. Right? No magistrate or police officer shall be compelled to say, underline the word when. W-H-E-N. When he got an information as to the commission of any offence, and no revenue officer shall be compelled to say when he got any information as to commission of offence against the public revenue. W-H-E-N. This is corresponding to section 125 of Indian Evidence Act. Jot it down, 125 of Indian Evidence Act. Anybody has got Indian Evidence Act with you? 125? Please read. I told you to underline the word when. When means, what is the meaning of when? Time. At which time? Which date? Okay. Now read section 125 of Indian Evidence Act. Shankarji, you have got Indian Evidence Act? Anybody has got Indian Evidence Act? Shankarji, please read. Read section 125. All please listen. You have a mic for him? Have a mic for him? Shankarji, 1 second. Section 125 of Indian Evidence Act. Shankarji is going to read.
Section 125.
Listen carefully.
Information as to commission of offences.
Which is equivalent to section 131 of BSA. Yes.
No magistrate or police officer shall be compelled to say whence.
Spell it.
Whence.
Spell it.
W-H-E-N-C-E.
Now Shankarji is telling in section 125 of Indian Evidence Act, the word used was whence. Whether when and whence are same or different? Whence means source, where and when. The word whence means it is a combination of two words, that is where and when. Now previously you cannot ask with a police officer or a magistrate Which is the source of information? Because the word used was whence. Now the word is when. Now you cannot ask him the date or the time, but what you can ask? Now, now you cannot ask when. Now you can ask whence. That is where. See, I am repeating once again. The word whence is a combination of where from, that is the source, and when, that is the time. Now, section 131 contains when. So, I cannot now ask the policeman the date or time of information. But I can ask the policeman what? Where from you got? Source can be asked. So, this is one important thing for the advocates. From 1/7/2024, section 131 says no magistrate or police officer shall be compelled to say when, that is the time, date of any information. Now Shankarji is telling 125 says, tell me my dear.
No magistrate or police officer shall be compelled to say whence he got any information as to the commission of any offence, and no revenue officer shall be compelled to say whence he got any information as to the commission of any offence against the public revenue. Explanation. Revenue officer in this section means any officer employed or is about the business of any branch of the public revenue.
Excellent, my dear. You understand? Now it is, thank you, ma. Now it is, now section 131 speaks of what? Whence or when? Previously? Now we can ask about source. Understand, dear? Yes. Then, so, yes. Come to section 73, BSA. What does it speaks of? 73. Proof as to verification of digital signature. There are two types of signature now. Electronic signature, digital signature. Okay? Any person from this side? You are all looking very smart, young boys. What is the difference between electronic signature and digital signature, my dear? Electronic signature, digital signature. If there are two words, there will be. If there are two different words, there will be two different meanings. Excellent. So there will be different connotations. Electronic signature, digital signature. This digital signature is defined in IT Act of 2002. Electronic signature is less what? Authentic. Excellent, sir. Electronic signature is less authentic. Digital signature is more authentic. It is certified by somebody, some agent, that this digital signature is authenticated properly. So this is the one difference. Please read the IT Act for understanding what is digital signature. Okay? But what is not defined? Digital signature is defined. What is not defined? Digital record. Excellent. So if you find any other good source of definition, share with your brothers. Okay? Then 61 and 63 we have already said. 61 deals about primary documents. 63 deals about what? Morning we started with 63. Yes. I will read 61 for a moment. Please wait. BSA. It says, 61 says, electronic or digital record, nothing in this Adhinayam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic or digital record, and such record shall, subject to section 63, have the same legal effect. What is section 63? Section 63, 61 says all electronic records are admissible. Court cannot say that it will not admit. But 63 says how a secondary electronic record is admissible. So 61 is subjected to section 63. If 61 has to be relied upon by the court, 63 also should be taken into consideration. Okay? Yes. Then, more than that, I don't think there are any other important this thing. You can come to section previous 165. Please come to section 168 of BSA. 168. Judge's power to put questions or order protection. This was the old 165. The 168 here was the old 165. What was 165 is, any court can put any questions. 165 will say, any court can put any question to any witness in order to bring the truth. Excellent, sir. Any court can put any questions in order to bring out the truth, can summon any witness, can order for protection of any document. So 165 of Indian Evidence Act, the power was too much for the court. Now come to 168 of BSA. Now it says the judge may, in order to discover or obtain proof of relevant facts, ask any question he considers necessary in any form at any time, any witness or the parties before any fact, or may order for production of any documents, neither the party then, provided that the judgment must be based upon facts declared by this adhinayam to be relevant, then now a reading of section 168, the powers of the judge which was given under 168 of asking anything, either relevant or irrelevant. Previously it was relevant or irrelevant. Right? 165 contains the word relevant or irrelevant. Now proof of relevant facts. So 168 has restricted the power of the court. Now court also cannot ask details with regard to irrelevant facts. Okay? This is one another thing. Come to section 165G. 165. A new in Bharatiya Sakshi Adhinayam. New provision was added in that, that is, provided that no court shall require any communication between the ministers and President of India to be produced before it. Okay. Now, no court, this is a new provision. 165 last provision. Provided that no court shall require any communication between the minister and the President of India to be produced before it. This was a constitutional power which the President was already having in the Indian Constitution. Right? No court shall compel any President to give any communications between the President and the Council of Ministers. Okay? I will ask you one. This much is under the new Bharatiya Sakshi Adhinayam. We have almost finished. Only one question I will ask you.
One famous judgment, Rafael's case. Some 4-5 years back, we had one case during the last election, general election. What was the case? Rafael's case. Yashwant Sinha versus CBI. You know that? Please jot down that. Yashwant Sinha versus CBI. Okay, before going into that, I will ask you one question. You imagine that I was working in a management. Okay? Chandru was working in a management as a laborer. Even after 3 years, I was not regularized. What I will do? I will go to a labor court, ask for a regularization. Management, what they will say? He was not working with us. You understand the question? Now Chandru goes to the management, the office in the night time, break open and steal all the records and produce the stolen record before the labor court. Management files a case of theft as against me. My question is whether these stolen documents are admissible before the labor court or not. Sir is telling yes. Any other answer? My dear law college students, can Indian courts rely upon stolen documents? Yes or no? Yes, because the question before the labor court is only one thing, whether Chandru is working in management or not. The records which Chandru produces are relevant or irrelevant records? Relevant but stolen records. For that theft, management should take a different action. Management should go to the police and they should vindicate the offence of theft there. So now we will come to Yashwant Sinha's case. What has happened 5 years back? Congress filed a case as against the BJP government, stating that Rafael deal is a fraudulent deal. What is the evidence? They produced various records which are all official communications and not released in the public domain. Right? I am repeating, official communications which are all not in the public domain cannot be compelled by a court of law and they have got privilege. As we said, no advocates have got a privilege. Official documents, unpublished official documents have got a privilege. Now BJP government took a stand before the Supreme Court that these are all official records, it cannot be taken into evidence. What Supreme Court said, these official records have come out to us. We cannot call that. Now it is in front of us. So what has happened? The privilege? Privilege is gone. See, Supreme Court is not asking the ministry to produce it. Either it is stolen or we do not know what has happened. It is all in front of the court. Court said in Yashwant Sinha as a CBI, in India, courts should not see the source of documents. Even a stolen document can be taken into consideration for evidence. Right? Only thing is, court should see the relevancy and admissibility. If it is an admissible document, it is an admissible document. Then comes the proof. For example, I will tell another example and we will finish it for lunch. See, Chandru steals this cell phone. Chandru is committing an offence of theft. He steals the cell phone. Right? What is the fact and issue before the court? Whether Chandru has stolen or not. Excellent. Fact and issue before court, whether Chandru has committed the theft. Now policeman compels me to write a confession. I write a confession. Right? What I will say? I am Chandru so and so, born and brought up in so and so. I committed an offence of theft. Now what is this paper called? Admission before police. What do you call this paper? Confession. This paper is called confession. Whether this confession is relevant or irrelevant? Relevant. Because what is the fact and issue before courts? Whether Chandru has stolen or not. Chandru has already admitted that. So this is a relevant paper. Whether this is admissible or not admissible. So now comes the question, even though it is relevant, Next question will come whether it is admissible or not admissible. Because there is a bar in Indian Evidence Act which says we will not admit a person's admission before the polis as per section 25 of Indian Evidence Act. Suppose after admission I take the polis to the guest house in which I was staying and takes it from a secret place, whether this is admissible? Yes. What is the famous judgment? Section 27. Statement leading to discovery of fact. What is discovery of fact? Is the knowledge of the accused to the place and the object which is discovered. Which is the famous judgment? Whenever section 27, you just type out in Google section 27 Indian Evidence Act Supreme Court, one judgment will be there. Pulukuri Kotaya versus Emperor, 1947 Privy Council. Pulukuri Kotaya, Pulukuri, Pulukuri Kotaya versus Emperor, 1947 Privy Council judgment. This judgment speaks of section 27. What is the section 27? Disclosure statement made by an accused to the police, and this disclosure statement will lead to discovery of a new fact. The accused would have stated to the investigating officer the knowledge of the place and the objects which are hidden in there, and thereafter he would have taken the investigating officer there and he would have pointed out the place and the object discovered. Okay, Pulukuri Kotaya versus Emperor. What is the time now? We will break for a lunch and continue. You are all hungry? We will break. Yes. By which time we can gather once again. It is democratic. You can decide, but if you decide, you should be there. 230. Sure? Okay. Thank you so much. Ji. We will have. Yes. At last. We will finish all the three first. Yes, ma'am.
ಮಾಡಿಸಿಲ್ಲ. ನಾವಿದ್ದಾಗ ಎಷ್ಟು ಲಕ್ಷ ಇತ್ತು ಅಷ್ಟೇ ಇದೆ. 10 ವರ್ಷ ಆಯಿತು. ಎಲ್ಲ ಸ್ಟೇಟಲ್ಲಿ 20-25 ಲಕ್ಷ ಹೋಗ್ಬೋದು ಅಷ್ಟೇ ಕೇಳ್ಕೊಡೋಲ್ಲ. ಕೇಳೋದಿಲ್ಲ ಮಾಡೋದಿಲ್ಲ ಏನು ಮಾಡ್ತಾರೆ? ನಾನು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಯಾಕೆ ಹಿಂಗೆ ಮಾಡ್ತೀರಿ ಅಂತ. ಇವನೇನು ಮಾಡೋದು, ಅವ್ನು ಗಲಾಟೆ ಮಾಡೋದು, ಅವ್ನು ಮಾಡೋದು, ಈ ಥರ ಇದ್ರಿ ಹಿಂಗೆ ಆಗ್ತಾ ಸರ್. ಇನ್ನೊಂದೇನಾದ್ರು ಬಿಗಿನಿಂಗೇ ಎರಡು ದಿವಸನೇ ಫಸ್ಟೇ ಇಲ್ಲದೇ ಬುಕ್ ಮಾಡ್ಕೊಂಡು 2-3 ಇದಾವ ಜನ ಆ ಕಡೆಗೆ ಹೋಗ್ತಾರೆ, ಈ ಕಡೆಗೆ ಹಿಂದೆ ಎಲ್ಲ ಕ್ಲಾಸ್ಗಳು ಮಾಡಿಸ್ತಾರೆ. ಏನು ಇಲ್ಲ ಸರ್, 22 ಇದೆ. ದೊಡ್ಡದಲ್ಲಿ ರೈಸ್ ಮಾಡೋದಲ್ಲ ಅದು 17 ತೆಲಂಗಾಣ 20 GST ಇರೋದು ವೆಸ್ಟ್ ಬೆಂಗಾಲು 25 ಡೆಲ್ಲಿ 50 ವೆಸ್ಟ್ ಬೆಂಗಾಲು
Yes. Now we will go to Bharatiya Nyaya Sanhita 2023. Previously IPC contained 511 provisions. Okay. It was 511. Now Bharatiya Nyaya Sanhita has become 358 provisions. 358. So 511 of IPC has become 358 including repeal and savings. I have told you in the morning that the Parliament intend to change the name of Indian Penal Code into Bharatiya Nyaya. Indian Penal Code was prescribing what are the rights and liabilities under the substantive law. Right? You all were aware of the fact that there is a provision called as Article 21 of the Indian Constitution. What does Article 21 says? Right to life and personal liberty. Whether Article 21 gives the right to life or takes the right to life? Gives. How many of you says that right to life was taken by Article 21? Nobody. It takes. Who is telling Article 21 takes right to life? Behind the pillar. Yes, how do you say it, my dear? You are invisible. You can come and sit here. You don't want to see my face. Article 21, I will tell you one thing. Article 21 of the Indian Constitution, we believe that it gives you the right to life and personal liberty. How does it start? It starts with no person with a negative. It says no person shall be deprived of his right to life and personal liberty except in accordance with the procedure established by law. Now remove the no and remove that except. Read it. Every person shall be deprived of his right to life and personal liberty in accordance with the procedure established by law. In fact, Article 21 says, if at all a person's right to life and personal liberty has to be removed, it should be done in accordance with the procedure established by law. That's all. See, Article 21 is on the one hand. Death sentences are also there. Remand is there. Whenever any person is accused of an offence, police brings that person to a magistrate. What magistrate does? He deprives the person of his right to liberty. If you put that man into the noose, you impose a death sentence and execute it. Where is Article 21? If we believe that Article 21 gives only the right to life, it says that every person's right to life and liberty should be protected and can be removed in accordance with the procedure established by law. Because in any civilized country like our country, no person can insist upon rights alone. Every right has got a corresponding duty. I have a duty not to kill the other man. If I kill my neighbor, law will kill me. So, Article 21 says right to life and personal liberty means it is deprivation in accordance with procedure established by law. So it contains two rights. Okay, couched in positive and negative terms. Right? Okay. Coming to the word Bharatiya Nyaya Sanhita, the British people, they thought fit that it can be under the caption of Indian Penal Code. That is, they were under the impression or philosophy that if you commit an offence, you will be penalized. Now what has happened for the first time in this country? They have introduced a punishment called as community service. For that, you should go to, please note, section 23, subsection 2 and 3, BNSS. I am repeating, section 23, subsection 2 and 3, read with explanation, BNSS, Bharatiya Nagarik Suraksha Sanhita. This explanation of 23 subsection 2 and 3 explains what is a community service. Now please come to section 23 subsection 3 explanation of BNSS. Please come. You got it, my dear? Please read. Anybody read that? Read the explanation of community service. But for Shankarji, only Shankarji is reading, no one else is reading. This said, Amma, you can read. Yes. Any small children can read. Please read. 23 subsection 3 explanation. Community service means
Code of a marriage up to second class.
Ji, come to explanation. Come to explanation.
Community service shall mean.
Shall mean, please wait. Community service shall, the word shall is mandatory or discretionary? See, sir is reading, community service shall mean
The work.
the work. Underline the word the work. Community service shall mean the work. Then,
Which the court may order a convict to perform as a form of punishment.
so it is a work which the court order as a form of punishment for
Perform a form of punishment that benefit of the community.
the benefit, please sit sir, for the benefit of the community. So two things. Community service is a work. Understand? For whose betterment? For the convict or for the community? So community, please understand, community service is not sending the convict for meditation class, for yoga class. Two things are involved in community service, right? One is the court should give him some specific work. Let it be mental work or physical work. If he is an IT person, court can ask him to see an IT file for 1 month, right? He can go to an hospital or he can go to some other place where if that work is committed by some other person, that person would be given remuneration by the government, honorarium or salary. Now this person, the work, physical work, see, suppose Chandru is a carpenter. Court imposes community service on Chandru. Now I can be appointed or I can be put in a government building where carpentry work is going on. Some supervisor will be there. Now the court will say you do carpentry for 2 months without remuneration for the betterment of community. So please don't understand, community service means after you being declared as a convict, you will be sent for Sri Ravi Shankar ashram, right? Where you can nicely sit, eat for 3 times and make sightseeing. It is not for the betterment of that person's body or mind. Instead of putting that person in the walled world, what is walled world? WALLED, walled world. Prison. Our world don't have any walls. Okay? But married woman will not accept. That is not a work for, that is not the work for the betterment of the community. See, I will tell you 2 examples. I was taking a session in National Judicial Academy some 5 months back. Even before this act came into force,
2 district judges told me in a jovial way that one Madhya Pradesh High Court judge has imposed a punishment on a accused, that is a convict. That is, that person is in the habit of cutting illegally trees from forest. Judge told him, you should plant 20 saplings, within a week come and report. I am repeating, court said the accused is, the convict is hereby ordered to plant 20 saplings because he is cutting tree in the forest. 20 saplings and come and report. Question 1, on whose plot? The judgment doesn't say anything. On whose plot? Is it in a pot? He can also take a pot, put all the 20 saplings, nicely come and take a photo, report the judge, my lord, I have planted 20 saplings. This is point 1. Second is, on whose plot or land he should plant. Who should water thereafter? Court said you plant and come. See, an order should have clarity in that. It should have continuity also. See, these plants are small children. They are like our children. You cannot treat it very lightly. You go to any marriage hall, 2 murders are taking place. One murder is marriage. Second murder is giving small saplings. I have seen with my own eyes, people know they will just drop it somewhere on the route. In Chennai, where they will plant? There is little place for us to live. So don't commit murders like that. They are also like our children. So this is one thing. Second punishment is, one man in Uttar Pradesh was indulged in slaughtering cows. Perhaps it may be his business, his livelihood. Court said, I am sending you to Gosala for 15 days. Now the judge is asking, sir, if you send this man to Gosala, he will select cows for the next 15 days. So community service should not be like this. Community service should be a specified work, right, which should be for the betterment of the community. A slaughterer, if you are asking him to sit in the Gosala, what he will think? Each day, no, his greed will become more. Oh, this cow is very nice. This will be around 200 kg, this is 300 kg. He will plan of how to break the door once again and pull off the cows down. So community service is a work for the betterment of the community. So there are a lot of wrong messages in the mass media that community service is not explained. And if he doesn't do the community service, what will happen? These are all protests, these are all propagandas against the new laws. I have read 23 subsection 2 and 3 explanation. There is a nice definition. Instead of putting a man into the jail for small offences, for only 3-4 offences, I will tell the offences also while we are dealing with the 23, okay? Only for 6 offences it is prescribed. And section 8 of BNS, what is BNS? Bharatiya Nyaya Sanhita. Section 8 of BNS has to be read with this explanation, which says, if a person fails to do the community service, he will be put to jail. So community service is explained in 23 subsection 2 and 3, and punishment for non-obedience of community service is also explained in 8 of BNS. And we will see that also. See, I will just tell you. Please note down, community service cannot be given for all offences. It is only for few offences. Section 202, now it is BNS, like our IPC. Section 202, 209, 226, 303 part 2, I am repeating, 202, 209, 226, 303 part 2, 355, 356 of BNS. Shankarji, repeat. 202, 209, part 2,
355? Yes, of BNS. It is only for these small offences a community service is prescribed, not for any other offences. 23 subsection 2 and 3 explanation explains what is a community service. It is a work for the betterment of the community. 8 of BNS says if he does not oblige the community service, he will be put into jail once again. Okay, this is what is for community service. Now, for the first time in the country, but for sentencing a man in jail, now the parliament feels small offences, petty offences, a drunken man, right? He is using some bad words in the street. What is the purpose of putting him in jail? Right? Thing is, the quality of the liquor which went inside is very nice. So he has forgotten the world and talking. If you come to Pondicherry, you can see many people like that. Right? My birthplace. Not only for liquor, for Chandru also. There are so many temples there. Beautiful ashrams are there, temples are there, a nice seashore is there. And there are good people in Pondicherry who has not taken liquor. Right? It is just made to show like that it is famous for. So this is what is community service, and Bharatiya Nyaya Sanhita says this is not only penal code, that is, we are every offense. We are also thinking for reformation of people. So this is the caption, Bharatiya Nyaya Sanhita. Okay, what are the new additions? You will just see the new additions, you can jot it down. One is section 64, subsection 2, subsection 1. 64, subsection 2, subsection small 1. What does it say? 64, subsection 2, small 1. Whoever being a police officer commits rape within the limits of the police station to which such police officer is appointed, or in the premises of any station house, or on a woman in such police officer custody, or in the custody of a subordinate police officer, being a public servant, commits. These are all, this 64 subsection 2, subsection 1 is a new addition, within the limits of the police station. See, previously it was within the police station. What does it mean within the limits of the police station? Yes. Because Parliament thinks this policeman should not think him as an emperor. See, Parliament is protecting women. That means Parliament would have taken note of the abuse of women by the police within the jurisdiction where the police station's power extends. Now it is not that it should be done, he should commit and rape only in his police station. It is anywhere within the limits. This is what the intention of that. Okay. This is section 64, subsection 2, small 1. Then you see, previously rape was in which provision? 376. The Union Law Minister, Honorable Minister, who is the Law Minister? You are not updated. Arjun Megwalji. He said, this is the government which takes care of women. Even in IPC, we have taken them forward and grouped all the offences together from 64 to 71 of BNS. Previously it was in 376. Now it starts from 63. 63 is a definition of rape. It extends up to nearly 71 of BNS. Right? Yes. 71 of BNS. Please note 64 to 71, all type of rapes were grouped together. Okay, this is one thing. Then, please come to 69. Before, what is 69, my dear? No? What is 69 BNS? Please read. Intercourse by
then whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same has sexual intercourse with her. See, normally in the heat of the love, there are so many cases where man makes promises for marriage, because a woman will not accept for a sex unless she has a promise that this fellow will be a part of my life. Right? We are all not animals to have sex with a woman and drop her at the street and walking off and telling that this is a civilized country and we are all civilized. Right? So women, mostly she will say that I want you to be the partner of my life. And there are instances of man giving lot of promises. Right? What is there in giving a promise? I will definitely marry you. Previously what has happened, under IPC, Indian Penal Code, this is not a punishable offence. What happened, there is only one provision called as rape under 376 or cheating. Cheating is defined in 415 of IPC, punishable under 420. What this all woman police will do is, if a woman goes with a story that this man had sex with me, then they will ask her, why is that you consented? What will be the answer? This man said, I will be your better half. Now what has happened? This man has become the bitter half. Right? This lady will lose her chastity, will lose her morality, everything. And this policeman used to file a case under 417 of IPC. Offense is 2 years. Right? Gone are the days. Tell all your boyfriends. Right? Boys should say to the boyfriends, and girls also should tell the boyfriends that now the punishment is under section 69, which is sexual intercourse by employing deceitful means. Any man after 1/7/2024 wants to make all these deceitful practices, okay. And in Bangalore you have got big parks also where a lot of promises will happen. I came through that Cubbons Park or what? Is it famous for all this? All promise. It would have seen thousands of promises. Right? Put a note there. There is one provision called as section 69. Right? Sexual intercourse by employing deceitful means. I will read that one provision which is very nice. Whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same has sexual intercourse with her, such sexual intercourse not amounting to the offense of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to be fined. So this is one welcome move which is over and above section 417 of IPC, where that girl was not rewarded properly. 2 years, right? In that 2 years also we'll go inside and lot of birthdays will come for our national leaders. Each birthday of a national leader will give one remission. You know that? And this fellow will go today and he will come tomorrow. Intervening so many birthdays. He will come out, and this was the justice which we were making for 100 years for the victim of rape. Right? Decently called as he makes a promise and he will not live with her. This is what is in section 69. Then come to 95, which is a welcome provision. 95. What does 95 says? Yes, because there are rises in offences committed by the juveniles. It is commonly believed that these children are not committing the offence on their own this thing. See, I am seeing you all very beautiful, sitting in nice advocate dress, with coats, with robes. Imagine for a moment that when you are below 18, a vicious neighbor of yours has put you in a vicious crime. So we should always thank our parents and the neighbors for being very good with us.
And if at all a small child is manipulated from 1/7/2024 for committing an offence, Parliament says it is punishable under section 95. Hiring, employing, engaging a child to commit an offence. Previously, such an offence was not there in Indian Penal Code. Now 95 is the answer for that. So please take note of 95 also. Then come to 103 subsection 2. This 420 has gone, you know. What do you call in Kannada 420? Huh? Mosa. Okay. Now that, what is in Hindi, ma Hindu? 420. No more 420. It has 420 has become 318, 318. Okay, note that 420 has become 318 of BNS. Right? Then our 302, famously called as 302, no, that is also not there. It is 103, punishment for murder. 302 has become 103, 420 has become 318. Please note that also. Now, 103 subsection 2 is a new addition. 103 subsection 2. What it says? When a group of 5 or more persons acting in concert. What is this concert? Previously we have 2 phrases for this. One under 34 of IPC, another under 149. Common intention, 34. 149, common. Now it is common concert. Now the new word in BNS is, when a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life, and shall also be liable to be fined. So even if one man commits and the prosecution or investigating agency can gather evidence that this is an act out of concert. See, you could have seen only one man killing in the name of religion or community. If the prosecution and the investigation establishes to the court that it is not an act of a single man, it is on concert and people are behind him, if that is established, law says every member of that concert will be given punishment. Okay, my dear, this is 103 subsection 2. You call it as mob lynching. Mob lynching. Yes? Mob lynching. You do not know what is mob lynching. What is a mob? Yes, group of people for a good cause. If you gather for a good cause, you will not be called as a mob. No, Ji, if you gather together, no. It is an assembly, like our assembly. Yes, good cause. Then come down to 106 subsection 2. This is equivalent to our section 304A. What is 304A, my dear? Small little boys. After my lunch, I asked my brother friend who came with me, advocate, I asked him, the roads are always slippery and wet. I asked him whether people will do wheelings. He said, yes sir, all types of dramas will be there on the road. You commit a death of a person by rash and negligent act. Right? Now this is 304A. Punishment was only 2 years previously. Now the punishment was increased to 5 years by powerful bikes, powerless minds. Right? It is, see, you should think of one thing, responsibility. If at all we are that much brave enough to drive motorcycles at hectic speeds, we should participate in race.
Tell me one man from India who is participating in international race. We all drive the vehicle in 60 to 70 with throttling, that's all, and hitting an old man or a woman. Either she is dying or you are dying. You have the courage, join that school, participate in all the international this thing, and give credit to the motherland. And nobody is driving there. We are all driving in the roads, that too fully crowded, and in Bangalore it is wet also and slippery. You come to Madras, fully crowded, it is not wet, you will also be dry and that will also be dry. Okay. So now Parliament says, if a person drives a vehicle in rash and negligent way and he kills somebody, it is punishable for 5 years. Previously in 304A, death caused by rash and negligent act of a medical person also was there, doctor. For him, now the punishment is 2 years. For people who are causing death by any other act, but for medical persons, it is 5. Why such an exemption to medical people? Because the excellent intention will not be there. Okay? Intention, and especially doctors who are not in multi-speciality clinics, intention will be very good. You don't understand? Loans to repay. See, we should believe doctors, teachers, judges, our parents as gods. Right? Sometimes they may not be godly. But generally we should believe the system. See, doctors are gods. You just recall the service of doctors and medical people during Corona. It was exemplary, no? But for them, many of us would have died. So, Parliament has a sympathy, or Parliament presumes, as Sir has rightly said, that doctors will not have an intention to kill anybody. So, the punishment for doctors is only 2 years, for others it is 5 years. Then come to 106 subsection 2, which is not notified, but it is felt as very dangerous. 106 subsection 2 of BNS. Read that whoever causes death. See, suppose Chandru is going in a vehicle with 5 of my friends. One person has hit on the road and causes death of the person. All other 5, we can open the door and keep moving to our house. Responsibility is now fixed on the person who causes death by rash and negligent driving. That person is mandated to inform to the police or to the magistrate immediately after death that I have caused death of a person. Why? What may be the reason for this? Amma? Next point. See, there are a lot of hit and run cases. People escape, delay is there. What is the main purpose? I hit somebody and run. The other person's life maybe would have saved if at all information is given to the police or magistrate at the earlier point. This is also a very fantastic provision which the Parliament has made. Any person who causes death should inform immediately to the police or magistrate, failing which he will be imprisoned for 10 years. Punishment is 10 years because, as you all rightly said, see, I may be the head of the family, or I may be the tail of the family also, that is immaterial. A child may be the tail of the family, that this tail will become the head one day. See, killing somebody on the road is very, very sympathetic, pathetic. Imagine that one amongst the family members of us is hit for no reason and put to death. Think about the next generation. What will happen to the next generation? Suppose my father has faced a death like that when I was in my second or third standard. You will not see a man like this here standing. Chandru will be working as a mason or carpenter, or Chandru would have contested some elections and won. Right? I do not know. But definitely I would not have went to school. What my poor mother will do. So be very, very careful when you are sitting on the accelerator. You are killing somebody. You are not only killing that man. You are spoiling the next, second and third generation. Imagine a family which is without a husband, without a wife. Think of the children, or just think it like that. You hit and kill a child. For aged parents of 40 to 45, will they have a child back? So please be very careful when we are on road. Parliament has rightly made all these provisions that in hit and run case, you should definitely inform at least that person could be saved at least. Right? So this is also a welcome provision, 106 subsection 2, not notified. Then come down to 226. That is what I also told you, not notified. Yes. Not notified, will be notified. I do not know. Yes, only parliamentarians knows. Come to 226. 226 was previously 309. Two people will threaten always that they will commit suicide. One in the house, one outside the house. Tell me, I will check your intelligence. One by wife, another by opposition leaders. What opposition leaders will do always? They will come and sit and say they are going to starve, hunger strike. Right? Outside the home and inside the home. Inside the home, husbands will always come and complain that my wife is threatening that she will commit suicide. 309 IPC says attempt to commit suicide is punishable. Section 107 of the Mental Health Act, note down section 107 of the Mental Health Act says those people who intend to commit suicide should not be punished. Why? They are mentally suffering. I will ask you one question, including me. Can anybody in this hall, including Chandru, say that I am mentally health for 100%? Who is mentally health? Who is having mental health 100% in this hall? If you say you are mentally healthy, your wife will say the opposite. Will any wife certify any husband as mentally healthy person? What she will say? If the boy creates some nuisance, she will say, you are like your father, both mads. Right? But law says, any person who attempts to commit suicide is mentally ill. That person deserves treatment. In Bangalore, you are fortunate to have NIMHANS. In Tamil Nadu, we don't have any such big hospital. NIMHANS, no? Yes. But 309, it punished everybody. Now, 226 says, it is presently 226 of BNS. It says, we will not punish a person who attempts to commit suicide if he is mentally sick. However, if any person threatens the authority, public authority, or restrains the public authority under the name of committing suicide, then it becomes punishable. Okay? Yes. Attempt to commit suicide to compel or restrain exercise of lawful power. We can see people sitting on the road making all dharnas. Then morning they will come fully packed. Right? One lassi and one vegetable biryani. It will go up to the night. But they will sit, they will tell that I will not eat. He cannot eat for one day. But it will be in the name of hunger strike. Right? So all these dramas are punishable now. 226 of BNS. Then 117 subsection 3. Yes, 117 subsection 3. Voluntarily causing hurt. 117 subsection 3, the word persistent vegetative state is very important. 117 subsection 3, word persistent vegetative state. See, there was one case of a sister in Bombay, her name is Aruna Shanbag. When she was 24 years old, she was in duty in King's Edward Hospital in Bombay. One man, a sweeper, who was hormonally imbalanced on that particular day, he thought of committing rape on that lady.
What he did, he has not committed only a rape simpliciter, he put a chain around the neck of the sister, tied it and raped her. What has happened? The sister slipped into a coma because there was a deficit of blood flow and oxygen from the heart to the brain. She remained in that vegetative state for 40 years. 40 years. Just imagine. A lady, and you read that Aruna Shanbag's judgment, Supreme Court is writing, the bones have become like pencil and the flesh has become like a skin. This is the pictographical version of the sister who is in coma. See, this is a result of one idiot. We cannot call him as an animal. Can you ever call a man doing like this as an animal? Animals are more disciplined. Just show me one animal which makes a gang rape. Show me one animal takes a screwdriver and puts it in the sexual part of a woman. What is the event that we have faced in Delhi? Nirbaya's case. The girl's vagina was torn from the navel till the anus. 4-5 people inserted their hands, their legs, and what is that? Iron rods which are used to tighten the wheels. And all paper says animalistic act. Which animal has done all this? Thank God animals cannot read your newspapers. If animals have ever read the newspaper, no, and if there is any court for animals, defamation of the worst sort, it would have sued the newspaper. No animal is like us. We pretend that we have 6th sense, 7th sense, 8th sense. We are very godly. But all our acts, no. Even I don't think demons will do that. So I cannot call demonly acts. Show me one demon or an animal which has put 5 hands in one private part of a woman. Right? We are all, see, this is the reflection of the parentage. See how that sons are like that? It is, I do not know. Think of that girl. Think of that fate of that girl's parents till date. They will be continuously crying. Things are not over by putting all this 5 to 6% onto the news. See, every minute the parents will be dying for the child. So we have a responsibility as advocates that our children, our neighbors should be taught not to do all this. No God will forbid all this. Right? First, we should behave as heroes. We parents should behave as heroes to our children. For me, my father and mother are the heroes. Right? We should look at them that they are all very tall figures. We should not fight with them. We should not set a bad example. We have a greater social responsibility. Like that, this sister Aruna, what wrong she has done? Her parents had made her a nurse. She has become a nurse. She was caught by the vicious eyes of that fellow. She was in deathbed for 40 years. 42 years. 42. See? 42 years in a vegetative state. Right? Now, Indian Penal Code, there was no provision. There is a provision only for grievous hurt or attempt to murder or murder. There is no provision if a man commits an offense like this, that is putting a person in permanent vegetative state. Right? So this is also a welcome provision which is in subsection 3 of section 117. Whoever commits an offense under subsection 1 and in the course of such commission causes any hurt to a person which causes that person to be in permanent disability or in permanent vegetative state shall be punished with rigorous imprisonment for a term which shall not be less than 10 years. What is the meaning, my dear? Which shall not be less. 10 is minimum mandatory. Can court reduce? No. This is called as determinate sentence. There are two sentencing in law. One is determinate sentence, another is persuasive sentence. Persuasive sentence means You can, a pleader can, after conviction, a pleader can go to the court and beg with the judge for reducing the sentence. In that it will be like this: court may convict for life, court may convict up to 10 years. What is the meaning of up to 10 years? What is the minimum punishment in that? 1 day. Who said 1 day? Give a big clap for him. This is not even like by beating mosquitoes. Right? Big applause. Come on, big applause for him. Thank you. See, whenever law says court can impose a punishment which may extend to 10 years, means where from it starts? 1 day. If court says it shall not be less than 10, 10 is the minimum mandate. Even if the judge thinks he cannot reduce, that is called as determinate sentence. That is, Parliament has already determined the sentence. Persuasive sentences, the lawyer during sentencing can go and persuade the judge for lesser sentence. Yes, lesser sentence. So these are all two types of sentencing which you should know. Then come to subsection 4 of 117. What is subsection 4? This is similarly like our 103 subsection 2. Is it? Isn't it? When a group of 5 or more persons acting in concert, this is the very important thing, acting in concert, causes grievous hurt to a person on the ground of all the grounds which we have stated in 103 subsection 2. Okay? Then coming to 152. What is 152? Previously it was 124A. What was 124A, my dear? What is sedition? What is sedition? Tell me, my dear, once again, loud. No citizen should speak against the government. Right? Now it was removed. That means Parliament now gives you the guarantee or authority that you can criticize the government but not the nation. If you do any actions which is against the sovereignty and integrity of the nation, you will be punished. So, the present Parliament believes that you can criticize the government and government have to take the criticism for better governance. This is what is said in section 154. So, 124A sedition was removed. Okay. Coming down to 195 subsection 1. This is assaulting or obstructing public servant when suppressing riot, because riots are now common. We have seen lot of riots in Delhi, no, for the CA and other things. That is, 195 is a specific provision introduced, assaulting or obstructing public servants when suppressing riot. Okay, then come down to 195(2). This is threatening to assault or attempting to obstruct public servant when suppressing riot. This is also a new introduction, 195 subsection 1 and subsection 2. Coming to 304. What is 304? Present 304? Present 304, BNS. Whether in Bangalore you have snatching? Cell phone snatching? Many? Oh, hundreds. So don't wear don't wear chain, that's all. What a person can snatch from me? I have nothing. He can only snatch this. My old mobile phone he will throw, sir. See, snatching was not an offense under IPC. Some states have included snatching by way of amendments. In Tamil Nadu, there is no offense like snatching. They were using only section 379, theft. Now snatching has become a new offense. You snatch anything, it becomes an offense. Cell phone or empty bag also. Sometimes you think that the bag will be nice, glittering. You snatch it only to see nothing is inside. But snatching is an offense. It is under section 304 now.
Then 324 subsection 3. Previously 427. What is 427? Mischief. And it is, punishments were very little for mischief. Below 50 rupees and above 50 rupees. Okay. Now a new provision is added for mischief, that is 324 subsection 3. Mischief causing loss or damage etc. to any property, including property of government or local authority. Okay, because we will be not worried when it comes to government property. You know that. If any leader dies or any leader is arrested or any new child is born to a leader, or if we won some T20 series or anything, which is the vulnerable property for us to attack? Government bus, government hospital, government schools. We take it for granted because we think we are part of government. But in our house we will not break anything. Right? This is Indian democracy. See, we should feel that government property is our property. And if you tell like this, then they will steal government property and they will tell that it is my property I am taking. If you ask them not to destroy also, they will not keep quiet. So now government has lost patience. Government says, section 324 subsection 3 of BNS says, mischiefs causing loss or damage to any property including government property is non-cognizable but bailable. Okay. Come to 341 subsection 3. 341 subsection 3, 341 subsection 4 of BNS. That is, by ignorance if you have counterfeit. See, now I am in Bangalore. Morning I went to a hotel for eating. One fellow has given me some money. I do not know whether it is real money or fake money. Because I am having one piece of note, no, counterfeit. You cannot imagine that Chandru is a counterfeiter. So law has given some exemption that a man who possesses counterfeit without intention to use it should not be punished. I will ask an example. Using this, can Chandru have packs and packs of counterfeit in my house? Why? Government says you can possess counterfeit without any intention to use it is not punishable. You come to my house, break open a room and find the packs of counterfeit. Can I escape? Can I take the defense that I am innocently keeping? No. So there is a difference in all this. Right? Then 111 subsection 2, very important. Whether you have any organized crime separate act here, like Maharashtra organized crimes, Mokaka. Here, in Bangalore. Here. See, I am not asking Coca-Cola. I am not telling about cola. Organized crime. See, Maharashtra, Gujarat, there are a lot of states which have a specific act called as, in Maharashtra they have called as Maharashtra Organized Crimes Prevention Act. Like that, I don't think Karnataka has got an act. Tamil Nadu also do not have an act like that. Now, these organized crimes were made as penal offences, those organized crimes, because some states are not having any mechanism to prevent organized crimes, terrorism acts. What is this organized crimes? Suppose Chandru steals alone. Chandru is a thief, that's all. If Chandru is stealing with a syndicate behind, then it becomes an organized crime. Any act which you make as a result of syndicate, it becomes a organized crimes. Then apart from that, there are also other elements which is specified in section 111 of BNS. 111 subsection 2 small a to subsection 7. Please note 111 subsection 2 small a to subsection 7 organized crime. 112 speaks of petty organized crime. 113 subsection 2a to 7 speaks of terrorist act. I am repeating, 111 subsection 2 to 7 speaks of organized crime. 112 speaks of petty organized crime. Then 113 speaks of terrorist act. I am repeating, why the intention of the parliament in bringing organized crime, terrorist act in general BNS, that is our IPC, old IPC, is that if there is a special law like that, procedures are special. And who is the authority to grant sanction is in the rank of additional DGP. And who can initiate an action under the special acts? SP. Now what has happened, if a normal station house officer, he comes to the conclusion that this person, which is a terrorist act or which is an organized crime, even a normal station house officer can implicate a person, can file a FIR, and it can be tried as a normal IPC offense. So this is a welcome move on the one scale, and it should not be misused or abused by the police on the other this thing. For this, what is the example? A surgeon's knife. A surgeon's knife will always be made for good purpose. If it is in the hands of a murderer, what will happen? So laws are made for good purpose. We do not know what the policeman will do, but we always believe there is a judiciary. If policeman is erratic, then there is a judiciary to take care of that. So we will just see what are these are all this much is the new sections. We will come to amended sections. Okay. Section 354 capital A of IPC, I am repeating, 354 capital A of IPC was amended as 75 subsection 2 and 75 3. 354 A, what is 354 A, my dear? Outraging modesty. Yes. Now it is amended as 75 subsection 2 and 75 subsection 3, which speaks of sexual harassment for punishment for sexual harassment specified in class 1 or class 2 or class 3 of subsection. Then what is the sexual harassment? Anybody can explain? Should there be sex in sexual harassment? No. Should there be physical contact in sexual harassment? See, we will imagine him for a moment as a woman. Right? I am sitting in the train in front of him. I am sitting in front of him in the train. Just I am staring at him, showing some signs, removing my shirt button and all. Law presumes that all these are sexual harassment. Sexual harassment is an harassment to the opposite sex, that's all. It is falling short of physical assault. Okay. This is now modified, amended, and it is in 75.3 and 75 subsection 2 and subsection 3. Now come to 354 subsection B of IPC, amended as section 76 BNS. I am repeating, 354B of IPC amended as 76 of BNS. That is assault or use of criminal force to woman with intent to disrobe the woman. It is called as, otherwise, what? What is voyeurism? What is voyeurism? Admiring a person without, yes, without a dress. Right? 77 was made as a gender neutral voyeurism. It is a protection for every sex now. How many sexes are there now? After Nalsa versus Union of India, 2014, what is the famous judgment? Nalsa. Navjot Singh. Right? There are three genders. One is man, another is woman, another is the third gender. Right? So 77 is voyeurism. Then 496 of IPC is presently section 83. That is a person with fraudulent intention going through the ceremony of being married, knowing that he is not thereby lawfully married. This is section 496 of IPC. Presently it is amended as 83. Then 344 of IPC amended as 127 subsection 4. 344 of IPC amended as 127 subsection 4 of BNS. Then 489C of IPC, I am repeating, 489C of IPC amended as 180 of BNS. Then 258 of IPC amended as 186 of BNS. 384 of IPC, 384 of IPC amended as 308.2 of BNS. Okay. So this much is in Bharatiya Nyaya Sanhita. Now we are going to the big brother BNSS, which is very, very important because it is with regard to procedural aspects. Okay. We will start, see, it will take some time. If you all want to sit, you can sit. I do not know how long it extends. I am ready because I know that the association has called me spending a lot of money. Okay. Point one, spending a lot of money on my travel and putting me in a good room, giving me a nice food. So your association has spent a lot of money. And second thing is, association has got greater belief in me that Chandru will finish all the 3 laws. I am ready for that. You are also ready? You will see after 5:30 or 6. Nice. I am ready. I will start with section 2. I will finish with section 531. That is, we are not seeing all the sections, only sections where there are amendments and alterations. So kindly cooperate. And I love this people in the auditorium because unlike in the other place, I have not seen 2 people talking. See, this is the greatest respect you can give to a person on the dais taking a session. If this man is also talking like a fool and we are also discussing something, there is no purpose. From the morning, I have not even seen one person talking with the other. They are seriously writing it down. So I am extremely happy. I told this to my learned brother who was having lunch with me. I said, this is just wonderful. People inside the hall are not talking. And I saw some people outside the auditorium, some 10 to 12, they are discussing something. Perhaps they may be discussing subject also, we do not know. Right, we are discussing here, they are discussing there. But inside the auditorium, you are all excellent. We will start it from section 2, subsection 1. We will go a bit like our, what express? Shatabdi Express. Vande Bharat. Yes. And this is all recorded. Even if I go a bit speed, you can take that record. And whenever you don't have any bad thing to do, you can listen to my lectures. You need not see my face. Okay, you can switch off the video and listen to this. We will start by section 2. We will start from section 1 to section 531. Okay, we will go a bit swift. Right? Anybody who wants to have a break for 5-10 minutes, you want to attend nature call or do something? All this after the session, see. We have no time. I will tell you my phone number. People are asking my phone number. It is 98433 98433 22433 22533 98433 22533 EV Chandru. Okay. My chamber is 54 Law Chamber, Madras High Court. If you have any real doubt, it will be answered. But don't ask why is that you are having hairs. Those doubts will not be answered. Right? You all had coffee. You are having? Yes. No, I don't have coffee and tea. Dork. Okay.
Instead of High Court, we can get two powers.
Then you come to Chennai.
I come to Chennai. We used to talk to replaced in Chennai. High Court good friend of mine. You have a website of your own.
I should answer.
Yeah.
I have a small executive.
Practicing in Boston.
Karnataka is
Incorporate person, we should have
nothing like that. There are small customers in most of our you want to have a break for 5 minutes with that most.
You can also be seated, please. Standing for a long time.
Okay, we'll start. Yes, people outside, you can come and sit. You can have BNSS book with you. First, we'll start from section 2, section 1. Please come to section 1. Section 1 speaks about short title, extent and commencement. Shankarji, please tell what is the extent after reading. Can you find the extent? No? Okay, what is the extent mentioned inside?
Nagaland to the tribal areas. To the tribal areas, but the concerned state government by notification.
No, bro, you tell me where is this, what is the extent?
Sir, it is applied to the whole of India except the state of Nagaland.
Where it is stated that it applies to whole of India? Where from you are telling? See whether in the provision is there like that?
No, sir, it is only excluding these two. It is only excluding these two, A and B, to the state of Nagaland.
So
and to the
it is an implied extension.
implied extension.
It has not said, like the previous CRPC, it is not mentioned that the act extends to the whole of India. It says it is excluding Nagaland and tribal areas. Okay, this is section 1. Underline that, note it. Come to section 2, subsection 1. Just keep coming with me. 2 subsection 1 small a. It relates to audio video electronic means. That is, whatever we are doing hitherto in this place at this point of time, things will become paperless. Either let it be the investigation or inquiry in the court, trial in the court, appeal in the court, anything that is made on the paper will become paperless, will be by audio video electronic means. That is, will be taken a videography and an audiography in that, a video along with an audio. So, from 1/7/2024, a transition has started. The Parliament intends that it should not be in the paper. So, section 2, subsection 1, small a is audio video electronic means. Coming down to section 2, small b, bail. D deals with bail bond. E deals with bond. Okay. What is a bail? What is a bail? What is a bail? Release of a person after an arrest. I will put it like this. It is a release of a person from a lawful custody either by the investigating agency or by the court. Okay? Releasing a person from the lawful custody either by the investigating agency or by the court and placing the custody with a third party. This is the part 2. Chandru is arrested by the police and in a lawful custody. Now Shankarji and Aprit comes to court and says, from this lawful custody, we will take his custody in the name of surety. And what does the surety says? Sir, don't worry. This fellow will cooperate in appearing before the court of law up to judgment. This was not defined, bail was not defined in CRPC. Now for the first time, bail is defined in section 2, subsection 1, small b. Okay, come down to D. D speaks about bail bond. E speaks about bond. What is the difference? A simple thing I will tell you, you can remember. You need not even read that. Bond is personal binding, BOND. You remember it as bind. Bond is binding personally. That is, the person accused himself will bind himself by a personal bond. That is, he will guarantee the court, sir, I will come, I will appear. Where is the surety? No, sir, I bond myself. He will write a bond. He will bind myself by writing a bond. This is bond. Bail bond is written by a surety. Understand, my dear? Bond is personal binding. Bail bond is by surety. So we should have all these three very clearly. Bail is replacing the lawful custody of a person to a third party custody. Bond is personal binding. Bail bond executed by sureties. That's all. This is 2 subsection B, D, E. Okay. Come to 2 subsection 1 I, electronic communication. Morning itself we have dealt elaborately about electronic documents and electronic communication. 2 judgments we saw. What are the 2 judgments? Then Gopala Krishnan alias Dilip, Arjun Pandit Rao Kotkar versus Kailash Krishan Rao Gorantil. 2 judgments. And in Arjun Pandit Rao, I have made you to refer one para 63, which is the electronic draft rules committee of November 2018 by the meeting of Honorable Chief Justices. Okay. So this would suffice for 2 subsection 1 E, electronic communication. Then I will take your attention for a minute to 2 subsection 1 A. For 1 minute come to 2 subsection 1 A. What are the last lines in that? And by such other means as the state government may by rule provide. So we are awaiting for the state government to make rules with regard to electronic, how to deal with electronic. Yes, that is for reception, retrieval, authentication and preservation. All this government will make rules. Till then you can rely upon Arjun Pandit Rao Kotkar and the electronic committee's report, which is found in Arjun Pandit Rao Kotkar. Okay. Then come to section 2 subsection 1 L, investigation. Who makes an investigation? Tell me. We commonly believe that investigation is made by IO. We commonly believe investigation is made by police. That is wrong. Investigation is either made by the police or by any person authorized by the magistrate to do so. This was in section 2 subsection H of 1973. Now it is in 2(1)L. See? 2 subsection 1L, investigation includes all the proceedings under this Sanhita for collection of evidence conducted by a police officer or is a disjunction, or by any person other than a magistrate who is authorized by a magistrate in this behalf. That is, investigation is not the domain of IO themselves. Any person authorized by the. That is the reason previously under the CRPC what we will do, we will file an application under 156(3). What we will ask for? Fair investigation, proper investigation, speedy investigation. I am repeating, a magistrate court can order for 3 types of investigation: fair, proper, speedy. This is under 156(3). which is now 175(3) of BNSS. 156 subsection 3 of CRPC is now 175 subsection 3 of BNSS, where the magistrate court can order for fair, speedy, then proper. 173 subsection 8 is for further investigation. 173 subsection 8 of CRPC. which is presently under 193 subsection 9. 193 subsection 9. 173 subsection 8 is equal to 193 subsection 9. Further investigation. Okay. Constitutional courts, you can write it down. Constitutional courts like High Court and Supreme Court can order for reinvestigation, reinvestigation / de novo investigation, DENOVO. Constitutional courts can order for reinvestigation or de novo investigation or investigation by CBI. Reinvestigation, de novo investigation, investigation by CBI. These three investigations can be ordered only by magistrate, cannot order. You can read a judgment of Sakri Vasu versus State of UP. 2007 Supreme Court. Sakri, SAKIRI, Sakri Vasu versus State of UP, 2007 Supreme Court. Yes. Subsection 2 is also very important. 2 subsection 2 of BNSS is very important. It says, words and expressions used herein not defined but defined in IT Act 2000 and BNS 2023 shall have the meaning respectively assigned to them in that Act and Sanhita. From the morning I was telling you that the word digital records was not explained in all the 3 acts, because 2 subsection 2 says if something is not defined in BNSS, you go to BNS and IT Act also. But in IT Act also, digital records are not defined. Okay, my dear. Then. Last question, sir. We will have question section. Last, we will finish this. Okay. You should kindly cooperate with me. If we start to that, then this will stop. So I will finish by 5:31. The whole night I am here only. I will answer all your questions. Come to section 4 and 5 of BNSS. What is section 4? What is section 5? Section 4, brother, you got married, brother? You got married? No. First time. First time you got married. Yes. I asked a question, brother, did you get married? He said no. I asked him, brother, you get married for the first time? He is telling yes. So I think he has got proposals for several marriages. Very dangerous man this man is. Okay, question is, brother, who was the queen in your house before marriage? Mother. Section 4 of BNSS says CRPC, that is BNSS, general law is all powerful. When your mother became powerless? After the wife came in. So wives are like special laws. Whenever any special law comes, special laws will eat away the general laws. Generalia specialibus non-derogant. Generalia specialibus non-derogant. That is, general laws should give way to special laws. This is what is section 4 and 5 of BNSS. So, BNSS is a general law. Procedure of BNSS will be followed for BNS offences. That is, IPC offences, procedure was CRPC. Special Act procedures are the special law. Suppose special law is deficit, some procedure is not prescribed, then it can take the guidance of CRPC. Like that, Same thing is presently section 4 and 5. There are some good families where both mother-in-law and mother both, there will be two queens and husband and father will be like slaves. Right? There are some families like that. Two men will be ruling the family and all the men will be slaves. Like that, section 4 subsection 2 also says, section 4 subsection 2 also says, if the special law doesn't object to general law, then general law also can guide. Okay, so 4 and 5 is very, very important, you should read. Coming to section 6, jot it down, 6 has to be read along with 22 and 23 of BNSS. Section 6 should be read with 22 and 23 of BNSS. What is section 6? Classes of criminal courts. How many, do you have a metropolitan magistrate court? Even after 17? You closed the court. Cannot close the court. Because pending cases has to be there. Some 17/2024 law says new cases to metropolitan magistrate courts will not be there. That is, in fact, they are abolishing that. That is, you cannot file afresh from 17 before addition. Sorry, it is assistant sessions. Assistant sessions, metropolitan magistrate and chief metropolitan magistrate and judicial magistrate of third class. All these three abolished. I am repeating, judicial magistrate third class abolished, metropolitan magistrate abolished, then assistant session judge abolished. From 17/2024, that means pending cases, for that court will be there, that judge will happily finish it. We do not know in 5 years or 10 years, he will finish it, then only that court will get wind up, right? Prior to that, that will be there. This is one thing you all should remember. So now currently what will happen in the class of criminal courts, what courts will be there? Judicial magistrate, chief judicial magistrate, district, for district that is session judges. I am repeating, in the hierarchy, magistrate, judicial magistrate, chief judicial magistrate, sessions court, / additional sessions court, above that Supreme Court. Okay, so this will be from 17/2024. This is, it is in a different section, G. It is in section 15. We are talking about classes of criminal code, section 6. Okay, as sir has said, it is in section 15. You can also note section 15 of BNSS should be read with 162 of BNSS. 15, I am grouping all the relevant provisions. Section 6 has to be read with 22 and 23 of BNSS. 15 has to be read with 162 of BNSS. Just group it. Section 15. Whether in Bangalore, police officers will be given executive magistrate's power? Not now, previously.
Under the Police Act, they used to be given, not in the writing.
In Tamil Nadu, no police officer will be given the power of an executive magistrate before 17. But section 15 says, a police officer above the rank of SP, underline section 15, BNSS, a police officer above the rank of superintendent, a police officer of the rank and above SP of police will be given executive magistrate power from 17/2024. This is to reduce the workload on the executive magistrates. This 15 has to be read with 162. Excellent, of BNSS. Now come to section 18, subsection 8, proviso. 18, subsection 8, proviso. This is very important for lawyers appearing for the victims. Right? Any lawyer who is appearing for a victim will file a special wakalat. It was done under 24(8) of CRPC. Now it is done under section 18, subsection 8, proviso. What does it say? It says, provided that the court may permit the victim to engage an advocate of his choice to assist the prosecution under this subsection. That is, apart from 18 speaks of public prosecutor. Who is a public prosecutor? In this country, a victim After a victimization, that is after getting a what? After getting an injury, the victim does not know what happens. She goes to the police station, she do not even know what is the FIR. See, suppose think like that. Somebody is putting a knife in my neck, right? What is the offense? Sir, you want me to die immediately? I said somebody puts a knife in my neck. If I doesn't die, attempt to murder. Imagine what I know. After that, somebody will come with me, he will lodge some FIR, that's all. When I will be called to the court? When I am examined after 5 years or 10 years, I would have forgotten everything. In FIR, one story will be there, 161 another story will be there. I will depose something in the court. You defense lawyers will tell one story. What is the story? Inconsistency. What will say? My lords, you please see the FIR, one version, written by one A. And B is my 161. My evidence is C. All this will not go together. This victim should be defended properly by an agency called as investigating agency in finding out the truth. Point 1. Point 2 is public prosecutor should conduct the case properly. If these two things doesn't happen, what is the fate of the victim? What happens is the victim undergoes a secondary victimization. Undergoing the crime is a primary victimization. Undergoing the process of getting justice is secondary victimization. See how beautifully Supreme Court is telling. A victim can also have a private pleader of his or her own choice. Now you read one judgment, Rekha Murarka versus State of West Bengal. Rekha Murarka versus State of West Bengal. You should definitely take a printout and read. Supreme Court has said, what is the role of that private pleader? It is an expanded role. Right from the very beginning you can assist her. Okay. Also read the judgment of Aparna Bhatt versus State of MP. Aparna Bhatt versus State of MP. APARNA, Bhatt, BHATT. That is the reason I am giving the judgment. You read the judgment and show it to PP also, let him also learn. State of MP. See, brothers and sisters, I am telling you one thing. We should equip ourselves. Our knowledge is power. Court is not a place where we are going to fight. We should respect the court. Right? Judges are gods in human form, no doubt. But we have got a duty to plead before them and say that this is the right, this is the Supreme Court has said. If one court is not obliging for that, there is another court. So it is not a place where we can make ruckus. But we should know what is the right, what are the rights available, what Supreme Court has said. For each provision, there is one or two case laws definitely. Right? I will give you one judgment. Rammi alias Rameshwar, RAMMI alias Rameshwar versus State of MP. Rammi alias Rameshwar versus State of MP. It is right of re-examination. Right of re-examination by a person who has recorded chief examination. What usually we will do? We will take a chief examination. What is the next examination? Cross. Whether any one of us is doing re-examination. If you try to do a re-examination, then the judge will ask you one question. What is the ambiguity? Rami says re-examination is not only for ambiguities. It is more than that. So please read Rami alias Rameshwar. All PP should definitely read. All plaintiffs should definitely read this. Okay, Rami alias Rameshwar deals about the right of re-examination in every trial. Okay, then write the judgment of Hukum Singh versus State of Rajasthan. Hukum Singh versus State of Rajasthan. It is 14/9/2000, Supreme Court, Hukum Singh, Hukum, Hukum Singh is the state of Rajasthan. This judgment gives the public prosecutor for a right of interview. Hukum Singh gives the right to the public prosecutors the right of interviewing the witnesses prior to putting them in the box. You understand what I am telling? Public prosecutor need not do it hide and seek. Witnesses in the list of witnesses are his witnesses. He can call to the office, right? He can explain them what is the case. He can ask them what are the things which are going to depose. So Hukum Singh, the Supreme Court judgment says public prosecutor has got a right of interview, right? Then Dalbir Kaur was a state of Punjab. Dalbir, D-A-L-B-R, Dalbir Kaur was a state of Punjab. 1976 Supreme Court. It holds that a public prosecutor can choose who the witnesses are, can choose which are the witnesses he is going to examine. But it should be a fair play to the court and to the cause of justice. Public prosecutor has a right to choose the witnesses. However, it should not be for the interest of his interest. It should be for the interest of justice. Right? Then coming to section 19 and 20. What is new is 19 subsection 3 is new. What does it say? I will read section 19 subsection 3. Without prejudice to provisions contained in subsection 1 and 2, where no assistant public prosecutor is available for the purpose of any particular case. Underline the word any particular case. District magistrate may appoint any other person to be the assistant public prosecutor in charge of that case after giving notice of 14 days to the state government. Suppose if there is no assistant public prosecutor in a court and government is not appointing, district magistrate for a particular case can give a notice to the government, and within 14 days if the government is non-responsive, he can appoint an assistant public prosecutor. You should also keep in mind this thing. Then 20, Directorate of Prosecution. I have told you that this BNSS has made a time frame, has fixed responsibility for every stakeholder, right? Has given more accountancy and transparency for everybody. Now this section 20, Directorate of Prosecution, 3 directors are there from 1/7/2024. One is the Directorate of Prosecution, and beneath him is the Assistant Directorate of Prosecution, and it is the Deputy. Should confirm it? Yes. So the sentences that the High Court can pass is any sentence under law, including confirmation of death sentence. 22 speaks of a session judge or additional session judge passing any sentence authorized by law, but not execution of death. 23 subsection 1 speaks of CMM may pass any law authorized by law except the sentence of death or imprisonment for life or imprisonment for a term exceeding 7 years. That is, a chief judicial magistrate can pass a sentence up to 7 years, not above that. Then coming down to 23 subsection 2. Now previously what is the monetary limit of punishment? Here 10,000 magistrates. Now it has become 50. Right? It is 50,000. What is the provision? 23 2. Then or community service. 23 subsection 2 speaks of or community service. 23 subsection 3 also speaks of community service. Then you have a second class magistrate here. You have. You don't have. Yes. So let us not worry about 23 subsection 3. Then we have already seen what is a community service. What is a community service, my dear? What is a community service? What for it is? It is a work. No, it is a work for the betterment of. So we have seen already what is community service, right? Then coming down, 25. it is a duty casted upon by the court, it is a duty casted on the court by the parliament that sentences in cases of conviction of several offences at one trial. Suppose a man is tried for wrongful restraint, wrongful confinement, right? And 324 simple hurt, and for attempt to murder also. Now the court wants to impose several sentences for each of the offences in one trial. Now 25 says, previously what will happen, the court many a times it will live like that. It will not say how the sentences will run, whether it will run concurrently or consecutively. What is consecutively? One sentence will finish, the second will follow the first. What is concurrently? Everything will go together. Now a mandate is cast upon the courts by the parliament that 25 subsection 1, the court shall, considering the gravity of offences, order such punishments to run concurrently or consecutively. That is, the court has got a mandate to mention whether it is consecutively or concurrently. Definitely the court should say. It should not just leave it like that. Okay? Yes. Please come to section 34 subsection 2 Roman 2. I have told you in the morning. 34 subsection 2 Roman 2. I have grouped 5 to 6 sections. What is 34 subsection 2 Roman 2? It is defining. Excellent. It is defining proclaimed offender. Now the punishment is, see, 34 subsection 2 Roman 2 is, see the last two lines. Imprisonment for 10 years or more, or with imprisonment for life or death under the Bharatiya Nyaya Sanhita. 34 subsection 2 Roman 2 explains who is a proclaimed offender. I have also told other provisions. 34 subsection 2, then I have told you to group. With regard to proclaimed offender, we have grouped already. 34 subsection 2 Roman 2, 84, 86, 107, 355, 356. Okay, for people who are not present, I am telling, you should group to understand 34 subsection 2 Roman 2, that is proclaimed offender. You should also read section 84 of BNSS, 86 of BNSS, 107 of BNSS, 355 to understand who is an absconding accused. 356 is for proclaimed offender. 356 speaks of trial in absentia, that is inquiry, trial and judgment in absentia. 356 speaks of that for proclaimed offender. 355 speaks of absconding accused because we have seen in the definition that a person can be proclaimed as an offender if the offence is punishable for 10 and more. Below that you cannot proclaim a person as a proclaimed offender. Even if he is absconding, section 355 will take care. I am repeating, section 355 speaks of absconding accused. If a person is not implicated for an offence which is not punishable less than 10 years, you cannot proclaim him as a proclaimed offender. You understand? Yes. Then coming to section 35, subsection 1 to 6. 35 subsection 1 to 6, which is equivalent to 41 and 41A of CRPC. 35 1 to 6, subsection 1 to 6 is equivalent to 41 and 41A of CRPC. What is 41A? 41A notice. 41 and 41A speaks of two things, my dear. 41 and 41A cumulatively read, the Supreme Court has many a time said, police has a right of or power of arrest. I am repeating, power of arrest is inherent in every policeman to arrest a person for commission of a cognizable offence. But that does not mean that he should necessarily arrest. You understand the difference? Supreme Court says 35 subsection 1 to 6, which was the older 41 and 41A, speaks of two things. Power to arrest is distinguishable with necessity or requirement of arrest. Please note down, power to arrest is there in all policemen. They should explain to the remanding magistrate what is the necessity or requirement for arrest. All defense lawyers here, I will give you a catena of decisions. Please read that. You can object even at the time of remanding. Right? Because now Supreme Court says serving of 41A notice, which is presently 35(1)(6), is mandatory. If this 41A notice is not served, it becomes a ground for grant of bail. So please write all these judgments. For bail also you can see whether 41A notice is served. If it is not served, you can tell the court that it is because of these judgments, this is a ground for grant of bail. I will tell you some judgments, please write. Joginder Kaur was a state of UP. Joginder Kaur was a state of UP. 1994 Supreme Court. Arnesh Kumar was a state of Bihar. Arnesh Kumar was a state of Bihar. 2014 Supreme Court. Yes, SG. All the judgments have guidelines in that. Joginder Kumar was a state of UP. Arnesh Kumar was a state of Bihar. 2014 Supreme Court. Satendra Kumar Antil, Satendar, Satendra Kumar Antil versus CBI. For all courts and all investigating agencies.
As against the police, Satendra Kumar Antil, magistrate should mechanically remand.
It is a guideline, see. Satendra Kumar Antil versus CBI. Switch off this. Satendra Kumar Antil versus CBI, 2021, 2022, 2023. 3 judgments are there. Please take all the judgments. As Sir has rightly said, all these judgments are guidelines for the police and for magistrates who are indulged in mechanical remand. Format is also there. Grouping of offences are done. So please take Satendra Kumar Antil versus CBI. 3 judgments are there. 2021, 2022, 2024. Along with that, also read Muhammad Asfaq Khan, ASFAK, Muhammad Asfaq Khan versus State of Jharkhand, 2023. Then Siddharth versus State of UP, 2021. Siddharth versus State of UP, 2021. Supreme Court, all these judgments are Supreme Court. Siddharth versus State of UP, 2021. This is with regard to section 170 of CRPC. Siddharth versus State of UP, 2021. With regard to section 170 of CRPC, equivalent to section 190 of BNSS. 170 CRPC equivalent to 190 of BNSS. That is, in offences where charge sheet is filed instantaneously after arrest, like traffic case, prohibition case, those offences, Siddharth as a state says, you need not arrest the accused, you need not produce the accused for remand or at the time of giving the charge sheet also. So small offences where charge sheet is filed without greater investigation, right? Siddharth says you need not harass the person by arresting and producing him at the time of filing of the charge sheet. So please read all the judgment. I am repeating, it is Joginder Kumar as a state of UP, please verify. Then Arnesh Kumar as a state of Bihar. Satyendra Kumar Antil versus CBI 2021, 22, 23. Muhammad Asfaq Khan versus State of Jharkhand 23. Then Siddharth versus UP 2021. Okay. All these judgments you should take a printout. Or you will remember only this face, some beard, that's all. Right? And you cannot even remember this face for a very long time. You will get scared. Right? Yes. Please take it, read all these judgments, argue in the court, giving judgments. If bar is very strong, then judgments will come like a fatty, good baby, healthy baby. Right? If bar is very weak, then children will come like me, thinny, bony and weak. Right? 35 subsection 7 is an addition, new provision, 35 subsection 7. Subsection 7. I will read it. It is a new provision. This also you can object at the time of remand. What does it say? We can read from the second line. 35 subsection 7. For easy understanding, I will take you to the second line. In case of an offence which is punishable for imprisonment of less than 3 years and such person is infirm or is above 60 years of age. Now go to the first line. No arrest shall be made without prior permission of an officer not below the rank of DSP. You understand it, my dear? If the offence is punishable for imprisonment less than 3 years and the person is infirm or above 60 years like me, then for arresting that person, what should be done? From DSP. So, when a magistrate is remanding, if you are moving a bail, you can see this also, whether this has happened. If it has not happened, you can take it as a ground for taking bail. Okay, my dear? Yes.
So, why should we take bail and let the arrest be declared illegal? Let the magistrate.
Which court?
Magistrate.
How magistrate will declare the arrest is illegal? You should go to a writ court. So, easiest thing should be done. Then he can say that it is an illegal arrest before a writ court. It will take time, no? Yes. Then 36 and 37 speaks of 36 and 37 of BNSS speaks for appointment of a designated officer. This is also, I have told you in the morning that this is called as BNSS, that is Bharatiya Nagarik Suraksha Sanhita. It means what? Citizen Protection Code. Previously, under the old code, there is no designation called as designated police officer. So, if any man is arrested, nobody knows where that man is. You go to the jurisdictional police station, they will say, no, he is not here. Yes. Sir has got rich experience. And any person on the criminal side will know this. Any person on the criminal side will know this. Police comes and arrests somebody, you have to search him everywhere, and even God doesn't know where he is. Because only policeman knows better than God. Right? Now this 36 and 37 says there should be a designated police officer, and the duty of every police officer is to inform the designated police officer the moment he arrests somebody anywhere in the district. If a policeman does not do that, it amounts to what? Dereliction of duty. You can register a private complaint. You can take action as against him. Now this is an additional protection for citizens. What? 36 and 37, designated officers. Any person arrested anywhere in the district, every policeman is duty bound to inform to the designated police officer. That police officer have to display in that office the details of arrest. You can just go and search and see, or else you can sue them for dereliction of duty. This is a very good thing, innovative thing, but it is all in the hands of the judges to implement all this. See, law will be there nicely. For you advocates and judges, we should implement. If somebody is not obliging law, I am once again telling, knowing law is not to fight with people. Is not to fight with any policeman or court. However, laws are not made by the parliament for the sake of playing. Right? Laws are made for some purpose. If that purpose is not satisfied or fulfilled by the stakeholders, we should definitely fight for that. For that reason only lawyers are here. Okay. That designated officer, the moment, see, sir, somebody is arresting me in J1 police station. That J1 man should immediately send it to the designated police officer. My people need not search for me in the entire district. If they call the designated police officer, it is his duty to inform about my arrest. Or else you can tell that a person was taken from my house. Even after such a long time, nobody has informed. Designated police officer is telling that he is not there. Then the policeman who has effected arrest should be taken into task for non-information. It is a dereliction of duty. I will tell you two important provisions. One is 166 and 166A of IPC. 166A capital A of IPC, which is equivalent to 198, 199 of BNS. 166 cap is equivalent to 198 and 199 of BNS. That is, 166 says disobedience of law is punishable. Any stakeholder, I am telling you, 198 and 199 you read, disobedience of law is punishable. That is, if any of the law, any of the provisions of this law is not followed by any of the stakeholder, it becomes a disobedience of law. You can file a private complaint. Public servant sanction and all stories have gone. New BNS says, if government doesn't give sanction for 120 days, now it becomes a deemed sanction. I am coming to that. See, I am telling you from the bottom of my heart that this law is a good law. See, he is expressing some difficulty. I am telling that it is redressed. You see how many families would have faced difficulty in accused being taken by police, no? Even till date you will not be knowing where the accused. See, there is something called as rule of law in this country. Law should be the supreme. And any stakeholder, they are only servants of law. They should know their limitation. If they doesn't know the limitation, you are all there only to fight for injustice and to get justice. I am telling that we should fight definitely for injustice. And we should not do all this, other things which are not in the purview of law. Right? For answering his question, section 218 BNSS. 218 of BNSS, deemed sanction. Section 218 of BNSS, deemed sanction. 120 days. I will read the provision, which is 218, prosecution of judges and public servants. This is a very important provision which says the government shall take a decision within a period of 120 days from the date of receipt of the request for sanction. And in case if it fails to do so, sanction shall be deemed to have been accorded by the government. This is called as deemed sanction, because in the erstwhile code, if sanction is not given, case will fail. This code says if government doesn't give sanction, it is deemed that sanction is given, court can get along with the trial. Okay?
This provision be still applicable if a private complaint is filed today under IPC. The offence happened 1 year before, it came to my knowledge now.
Yes. Yes. Then, section 40 speaks about private arrest. Can you all arrest? If a cognizable offence takes place in front of you, that too law college students will be very happy in arresting. Right? Law college students are here. Yes. Amma, you are interested in arresting somebody if he commits a cognizable offence? Yes. Super, ma. Section 40 says, arrest can be made by a private person, but he should not detain more than 6 hours. He should hand over to the police immediately. This is a new addition. Section 40, the time limit for retaining by way of a private arrest is 6 hours. Okay. Section 43, subsection 3. I told you in the morning itself, 43 subsection 3 of BNSS speaks about giving power to the police for the purpose of handcuff during arrest, during production before the court. This is 43 subsection 3. Please come to 43 subsection 3. Police officer may, keeping in view the nature and gravity of the offence, use handcuff while making the arrest of a person or while producing such person before the court who is a habitual or repeat offender or who escaped from custody or who has committed offence of organized crime, terrorist act, drug-related crime, illegal possession of arms and ammunition, murder, rape, acid attack, counterfeiting of coins and currency note, human trafficking, sexual offence against children or offence against the state. So from 1/7/2024, you will see many cases in the court, even during the accused being produced for remand, he will come by handcuff. But 43(3) starts with a rider. You see, police officer may. It means he need not compulsorily make a handcuff. One thing. Then what is this following lines? Police officer may, keeping in view the nature and gravity of the offence, use handcuff. It means that he should have some rationality and reasonability in using the handcuff. So the rider is there. Okay. What are the judgments in this court given by the Supreme Court is Prem Shankar Shukla, Prem Shankar Shukla versus Delhi Administration, 1980 Supreme Court. Prem Shankar Shukla versus Delhi Administration, 1980 Supreme Court. Sunil Batra versus Delhi Administration. Sunil Batra versus Delhi Administration, 1978 and 79 Supreme Court. Then Citizens for Democracy versus State of Assam. Citizens for Democracy versus State of Assam, 1995 Supreme Court. All these 4 judgments, Sunil Batra, Prem Shukla and Citizens for Democracy versus State of Assam, 1995, all these 4 judgments says, arrest is, using handcuff is the prerogative of magistrates. Supreme Court says, whenever policeman wants a person to be handcuffed, who should give the permission? Magistrate. Now 43 subsection 3 says, police can decide. Magistrate have no business. Okay. Now whether the Supreme Court law will prevail or this law will prevail? This law will prevail. Why? Supreme Court knowing about, see, Parliament knowing about all these judgments, in spite of the knowledge, Parliament has enacted this law. Unless and until this law is declared as ultra vires by the Parliament, what is ultra vires, my dear? Yes, if it is intra vires, then this will stand. If it is ultra vires, then this will go off. Okay? This is section 43 subsection 3. Come to 45.
Even then, under this law, police will mechanically handcuff a person.
For that there is a rider. That rider the person can challenge. Police may use, taking into view the nature and gravity of the offence.
Please, question and answer session will be in the last.
Yes, we will have it in the last. Okay.
Because the flow will better.
Gee, you think, no, you think within 5:30 we'll finish? Yes. Section 48. 48. This also you group it with 36 and 37. Designated officer, powers of designated officer, right? 36 and 37, group 48 also with that, powers of designated officer. Then coming to section 50, second line, What is second line? Immediately after the arrest is made. That is section 50, power to seize offensive weapons. Second line is included. Immediately after the arrest is made. Then please come to section 51, 52, 53. 50, I am repeating, 51, 52, 53, group it with 184. Finished. Now we will listen for some time. 51, 52, 53, I have told you we can group it with 184. 184 of BNSS deals with examination of a rape victim. 184 of BNSS deals with examination of a rape victim. 51 deals with medical examination of an accused. 52 deals with medical examination of a rape accused. 53 deals with medical examination of an accused by the direction of the court. Now, question is, why there is a specific provision like 52, medical examination of a rape accused? Is it very essential for examining the rape accused? Why? Excellent, excellent. Give him a big clap. What did he say? See, the DNA material which was available on the victim will be in this fellow. You understand? In a sexual assault case or in a rape case, I will tell you like this. There are instances, there are two types of rapes. One by penetration. Penetration is by the penis, by the male sexual organ. Another type is what we saw in the Nirbhaya's case. It is insertion. Insertion is not through penis, the hand or any other object. Right? If an insertion or if a penetration is made by the penis, what will happen? The vaginal area will undergo a tear, which is sometimes described as a 6 o'clock tear or a 3 o'clock tear or a 9 o'clock tear. The vagina will get teared because it is an assault, it is not a sex. Now law expects, courts expects that because of this man's penile penetration, this lady has sustained that much of injury. Reciprocal injuries are also with this person. You understand, my dear? Had he done a penile penetration like that and has torn the sexual organ of the girl, this fellow will also have reciprocal injuries. And the seminal matters of this fellow would have got transmitted to the girl child or the woman, or that woman's secretions will be with this man. And apart from that, what will happen is, even a small child, if she is 3 or 4 years or 5 years, that child also at times, because of the pain, it may also, with the small little teeth, it may also bite. It may also make some nail marks. Right? But what will be the impact of the small little teeth and small nail? If that fellow is examined after 2 or 3 days, that small nail mark and small teeth marks will vanish, disappear. So law insists upon, that to present BNSS insists upon collection of all the materials, DNA materials, which we can see in section 51, subsection 3, explanation small a. What does it say? Explanation, examination shall include the examination of blood, blood stain, semen, swab in case of sexual offences, sputum and sweat, hair samples and fingernail clippings by the use of modern scientific techniques including DNA profiling. Now the present BNSS makes very, very strict for collecting DNA samples and forensic evidence as mandated under section 176. Note down along with this section 176 subsection 3 and proviso. 176 subsection 3 proviso. What does it say? 176 subsection 3 proviso. Last 3 lines read, cause the forensic expert to visit the crime scene to collect forensic evidence in the offense and cause videography of the person on mobile phone or any other electronic device, provided that where forensic facility is not available in respect of any such offense, state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. That is, now 176 says, collection of forensic evidence is mandatory. I will tell you one example for this. In around 2017, in Himachal Pradesh, what is special in Himachal Pradesh? Simla. Simla, tourist place and apples. A small girl of 8-year-old, after school, every day she will be accompanied by her brother. One day she was walking alone. In the afternoon 3 to 3:30. The rapist waylaid her, smothered the mouth. See, you should understand one thing. Crimes are always done by lazy people. Problems are always created by lazy people. You see two husband and wife very busy. No fight in the family. You see one husband very busy, lady is a lazy lady, she will fight. And the vice versa also. This lady will start working in the morning. She will go run and earn something. This fool will sit in the house, sleep in the mattress always. First question, why late? Why are you coming late every day? Why is that your phone is engaged always? A lazy mind is a suspicious mind and a criminal mind. All crimes are committed only by lazy fellows. Any man who has the faith in the country, who has faith in his own hard work, will not commit any offense. Corruptions are made by whom? Lazy fellows. They don't have any self-respect. If a man gets some money without any work, sitting in a post, it means that that fellow is a cancer to the society. He is a lazy money, not afraid that this money is a bad money. Right? We all will die one day. What will remain? A good name, good money or bad money. If the good money is there, then your lineage will also not enjoy all this. Bad money is always bad money. That money will have curse with it. But we are not at all worried about that. Curse or no curse. Mahatma Gandhi is in all money. So every money is good money. Any man who takes corruption, no, in a way is respecting Mahatma Gandhi. Because you are giving Mahatma to him, he is not telling no. So we should teach our people, we should be a standing example that this country will progress only if there are good people, non-corrupt people. Corruption will not develop this country. Right? The whole intention of bringing all this law and introducing transparency, accountability is to fight for a non-corrupt society. Understand, my dear? What has happened in this, why I came is this lazy fellow is stopped the child, smothered in the mouth of the child. That is making it in an asphyxial state. Right? Putting some cloth and then smothered. See, you just imagine a 8-year-old child. It has no hormones in the body, no sex chemicals in the body. Physically, the body is not fit. It doesn't know that there is something like sex in this earth. Just imagine. POCSO cases. A child below 13, 12. There are cases where a small child of 2 years, she is penetrated, vagina torn, her chin bit off, eyes were bit off and taken. Right? Just a bit. And sometimes, no, they are biting the ribs and taking off. How can you call these people as human beings or men? I do not know what is the problem in them. You are doing all this with a person who is not aware of what sex is. Raping a woman also is something different. You just think of raping a child. This child was raped, killed and thrown off in the Hilela forest. This man left. What has happened? This has become a big issue. I am talking about the importance of DNA. Why BNSS is insisting on forensic and DNA is, this small child was raped, killed and this fellow happily left. Parents were in search of the girl child. They were searching in the forest. She saw the daughter lying dead. Right? It has become a big issue. The Director General of Police of Himachal Pradesh came there and a camp office was put. What will happen? It become a big news. Now police has to arrest somebody. Right? Whom they will arrest? On what basis they should arrest? What should be the basis? See, a child is lying in the forest. She was raped and killed. DGP has come. What should be the basis for arrest? How they can detect the accused? How can it be arrested? See, you are all very intelligent people. DNA. The child was raped. The child's vaginal portions will contain what now? Swab. Seminal fluids and swab. Any good thinking person will start from collection of evidence. Excellent, sir. Any good thinking people, good investigating agency will start collecting the evidence from the child or evidence in and around the forest, forensic material. Child has died. Only the forensic materials will speak now. Our police arrested some 6 persons. 6 persons because they are looking like that. Tall, black, hefty, 120 kg, perhaps some small mole here. In cinema they will show, no. Like that they arrested 6 people. And 6 people were given nice beatings. One fellow died. Now what will happen? This custodial death issue has become a big issue. DGP who was in the camp office ran down. He said, now I will call CBI. One man died. You thrashed 6 people. See, just by beating how are you going to prove the case? It is all unscientific things. Beating a man, then what will happen? This man, some confession they will give, 27. One man will go and take a child's panties, another man will go and take child geometry box, another man will go and take child's notebook somewhere, another man will take a child's slipper. And each discovery will lead to, and each confession will lead to one discovery statement. If it is shown in the media too much, courts will believe that this 6 will be sent to meet the maker, hell or heaven. What happened? Because of this one man death, CBI came. CBI went into the forest immediately for collection of forensic materials. They took swab from the child. They had the DNA profiling. Out of the DNA profiling, taking the DNA profiling in the hand, they then started suspecting some people. They took blood samples. You understand how investigation is made? They took blood samples from 400 people. What local police did, they know some astrology or astronomy. They will stare at some people and the other man also will stare at them. You come. Like that 6 were collected. Right? Not arrested. I am using the word collected. It is like collecting garbage. Right? They were all collected. Then these people took 400 samples. Out of that, one man's DNA was matching to the extent of 25%. It means what? My dear local children, it means what? Excellent, ma. That means somebody in this man's family is the culprit. They caught hold of that fellow and drew a biological tree. Who is your father? Who is your grandfather? Who is your nephew? Who is your cousin? They put up this thing and they shortlisted one man. Others they called and they took samples, nothing. They arrested one man after 1 or 2 months whose DNA matched 100%. That man was a woodcutter in that forest. He occasionally comes there and cuts wood and goes off. Right? Had a DNA examination not done in this case, just imagine what would have happened. All the TVs will be showing all the 6 persons as most dreaded accused. You imagine the heart of those people, what they will think. What they will think. What is this country? This country is doing injustice to us. We are all arrested on false premise. This also has promoted the Indian Parliament to introduce two new concepts in BNSS. One is DNA, another is forensic medicine. Now section 170, what is the provision I said? 176 subsection 3 mandates for forensic, collection of forensic evidence. So this is also one among the reason. Okay, then I will give you some judgments of the Honorable Supreme Court for the purpose of DNA. Okay.
So now I am one among the 400 people whose blood samples were collected. Police approached me. Why should I agree to give my blood sample? You cannot collect the blood sample of the whole world. There should be some reasonable grounds to suspect. And 400 is too high, sir. Too high a problem.
But ultimately what has happened? Ultimately.
Due process of law is important.
See, there are two things. I will answer to him. There are two things. One is right to life. When right to life can be guaranteed? If investigating agencies, there should be a fine balance. Investigating agencies should also be given minimum, just by taking a drop of blood from you, no heaven will fall down. It is after all the life and death of a small child, and because of that another man has died. It is two things now. One is custodial violence and another is a rape and death. Okay, my dear. Yes.
Sir, if they zero down on at least 10 people or 7 people, that's fine. But 400 people.
You join CBI and see the difficulty. My friend is fighting for human rights. He is a good advocate. Yes. 51, 52 and 53 has been read with 184. Right? 184 of BNSS speaks about this examination of victim also. Now BNSS says you cannot examine a rape victim without her consent. Please underline that a rape victim cannot be examined without her consent. Under the name of examination of a rape victim, what our doctors are doing? What our doctors are doing? A woman goes to a hospital with a story of rape. Immediately our friends there know, well-read MBBS and MD people, without any sense of shame in them, they adapt some tactics of telling the two-finger test. And what is the result of two-finger test? They are certifying the character of the lady. If two finger is accommodated by the vagina, which is called as per vaginum test, they say that she is in the habit of having sex. This woman is for a different purpose. She has come as a victim. Imagine some fellows putting two fingers in your eyes or ears or nose or your anus. Now the Supreme Court has said many a times that in Lillu alias Rajesh was a state of Haryana, Supreme Court has condemned two-finger test, and in state of Jharkhand was a Shailendra Kumar Rai, 2022, December, Supreme Court has directed the health secretaries of all the state that if any person ventures to do this, it is a medical misconduct and he shall be referred to the Medical Council of India for punishment. Okay, in the case of state of Jharkhand as a Shailendra Kumar Rai, 2022. So if the woman doesn't consent, even if the woman consent also, no food to two-finger test. The doctor is expected to write the injuries there, that's all. So perivaginum test and all is banned now. Okay, my dear. Yes. Judgments are Krishan Kumar Malik was a state of Haryana. Krishan Kumar Malik, M-A-L-I-K, was a state of Haryana. Please read this judgment. Krishan Kumar Malik was a state of Haryana. What does it say? Supreme Court has gathered so many forensic experts' opinion and says spermatozoa will not die within a short span of time. The life of spermatozoa, a dead spermatozoa, can be traced even after 5 years, and non-motile spermatozoa will be present in the woman's vaginal portion for around 5 months. non-motile spermatozoa are found in the woman's vaginal portion for more than 5 months. Because why I am telling all this is, a girl or a victim, if she goes to the police or to the doctor, no, after a week or after 1 or 2 days, they will ask her, have you urinated after the incident? Have you taken bath? Did you change the clothes? All evidence have gone. But Krishan Kumar Malik says the other way, that it remains for a very long time. Then Rajendra Prahalad Vasnik was a state of UP. Rajendra Prahalad Vasnik was a state of UP. Then Chotkau was a state of, Rajendra Prahalad Vasnik was a state of Maharashtra. Chotkau was a state of UP, 2022. Chotkau, Chotkau was a state of UP, 22. Then Munna Pandey was a state of Bihar, 2023. Also read Munna Pandey was a state of Bihar, 2023. In all these judgments, the Supreme Court has either condemned the investigating agency or the prosecution for non-collecting of forensic materials or improper use of DNA materials. So the message is, in the new BNSS, reading cumulatively 51, 52, 53, then 170. Yes, cumulatively it gives a signal that, which is mandatory. Forensic evidence collection is mandatory. DNA test is mandatory. Right? And you write another one judgment. Ravi was a state of Maharashtra, 2019. Ravi was a state of Maharashtra, 2019. Supreme Court says, the results of DNA test are scientific in nature. Results of DNA tests are scientific in nature and are reliable to an extent of 100%. Okay. Parliament, taking into consideration of all this only, introduced in BNSS the concept of DNA and forensic evidence. Okay, my dear. Yes, we will come to section 58. Last lines, one word is included, whether having jurisdiction or not, that's all. 58 last lines. Whether having jurisdiction or not, that's all. 63 to 70. 63 to subsection 70 speaks of forms of summons, summons house served, summons, service of summons on corporate, then proof of service. Digressing for a moment, I am taking you to 530 of BNSS. Please go to 530. What section 530 says? Trial and proceedings to be held in electronic mode, section 530. Then down the line is all trials, inquiries and proceedings under the Sanhita, including issuance, service, executions of summons and warrant. So we should read 530 subsection 1 along with 63 to 71. Yes, my dear. What is the period we are undergoing? I told, a transition period from paper to paperless. So 63 to 71 says issuance of summons, service of summons, proof of summons will be done in an electronic mode. Then come down to section 71. This is with regard to service of summons on witnesses. What it says, notwithstanding anything contained in the previous sections of this chapter, that is, you should give a quietus for section 63 to 70 for a moment, because 71 starts with a non-obstante clause. Whatever is said in section 63 to 70 is not applicable to 71, that is provision for service of summons on witnesses. What does it say? It says, court can follow in addition to and simultaneously. Court can follow two procedures. That is, they can issue summons by RPAD also, by paper also, and by electronic mode also if it comes to witnesses. Okay. Then one more addition in 71 is, subsection 1 last line is, you can also serve the witnesses summons for the first time under CRPC in a place where he carries on business or personally works for gain. These are all provisions which we have borrowed from CPC. In CRPC these words were not there. Okay, this is one addition. Then we'll come to 82, subsection 2 speaks of designated officers. Where we should group it? Yes, my dear. 82 subsection 2, where we should group? 36, 37, another one. I told you to group 36 and 37 with another one provision. Excellent. So 36, 37, then 48, then 82. All this has to be grouped together because they all spoke on appointment of designated police officer. What is the job of the designated police officer? Yes, by localized students. What is the job of designated police officer? Who should inform? Which police? Yes. Details of the arrestee. Okay, so we have grouped 36, 37, 48, 82. Excellent. 84 should be read with. See, 84 I have told you, it is with regard to proclamation of person absconding. Yes, my dear. So, loudly. 34 subsection 2, Roman 2, then 86, 86, 107. Excellent. Okay, we need not go through those provisions, we have already finished. With regard to proclaimed offenders. Then 86 I have already finished. Isn't it? 86 should be read with 107. In the morning I told you, no? 86 should be read with 107 because both it speaks for attachment of property. Can attachment of property be made by police independently without getting power of the court? Police cannot make attachment of immovable property in this country in view of the judgment of the Honorable Supreme Court in Niveda Properties Private Limited versus State of Maharashtra. Niveda. 2019 Supreme Court. Niveda Properties Private Limited versus State of Maharashtra. Honorable Supreme Court says police person should not be given the power of attachment of immovable property. If done so, it will lead to anarchy. Because police should ask the court for attachment of immovable property, or else he will become the king of the country. Okay. That is not the intention of the parliament. Section 105. Where is the sir who asked for search and seizure? Okay, it is his chapter, now it is coming. Section 105. Recording of, please come to 105. Recording of search and seizure through audio, video, electronic means. Come to the fourth line. Search and seizure and signing of such list by witnesses. You have it. Did you have? What is the word used? Section 105. Recording of search and seizure through audio, video, electronic means. What is the fourth line? Shall be recorded by audio, video means. Police officer, previously, they will write a form called as search and seizure form, form 95, which goes to the court, which shows the court that there is some search and seizure. Now, section 105 says, any policeman who is doing a search and seizure should record it. You follow? Is this a justice for accused or it is an injustice to accused? Why? A Hindu is telling police will not plant. I am telling the previous day they will come and plant. So, is there any possibility? There are possibilities. See, there are good people and bad people in the system. Some good people will do good investigation. Some bad people will do bad investigation. God knows. And what will be difficult is they have to plant at least now. Previously, whatever they want to write, they can write. These are all search, these are all seizure. They will tell accused family, you produce all this in the police station. See, suppose I am arrested for chain snatching. They will arrest my simpliciter. Take me to the police station. They will call my mother, my sister, my brother. They will tell, you bring 200 sovereigns within tomorrow. They have to bring. They will produce a long list. Right? In that list they will write all this. And now the court will see only the search, seizure, register. That is form summons. That is the form 95. Now, where from you are searching, where from you are seizing, you should make a audio video recording of all this. It is a difficult thing, and accused can always say that police have come to the spot yesterday, and accused, if he is very shrewd, he will go and collect all CCTVs. If police goes on that street, no, they will collect all CCTV and say, sir, they have come the prior day, planted it, and next day only the shooting has taken place. Now it is going to be a headache for the police, because search and seizure, recording of 161, recording of confession, everything is going to become audio video. Previously, if you have practiced in the criminal side, confession will be 8 to 10 pages. It is the healthy imagination of the police, he will keep on writing everything. What the judge will do, he will go to the last page, last 4 lines, take a green pen and put 4 lines. And on the side he will say, admissible portion, exhibit P5, exhibit P6, something. These are all the admissible portion where it will say that if you take me to the spot, I will locate the place and will take out the object. Now, if confession is in a video, audio video means somebody has to tutor the accused for 5 hours or 10 hours. You cannot ask an accused to talk for 2 hours, 3 hours, no, for taking out such a voluminous confession. So, this is going to be the real headache for recording confession. And 161 statements. One FIR will be there, all 161 statement will be ditto, the same thing. But if you are going to record by audio video means witnesses will not speak like that. It is very difficult to speak for 1 hour or half an hour, right? Which I am undergoing from the morning. Right? Then 107 should be read with. Excellent, ma. 107 should be read with. Array, my dear, we have grouped already. 34, 86. 107 should be grouped with 86. Why? Both speaks of attachment of property of proclaimed offender. 86 and 107. Yes. And advocates who are practicing on the criminal side, this 107 is a beautiful provision. Now it says prosecution can also take an ex parte order of attachment if they can prove that it is a proceeds of crime. And 107 further says at the end of the trial, if court finds that the proceeds of crime comes from different people, court will what? Entrust it to the district magistrate, and the district magistrate will distribute the proceeds of crime. In cinemas, heroes will distribute no proceeds of crime. In certain cinemas, no, they will collect from people and they will distribute like that. Now 107 says these proceeds of crime of this proclaimed offender will be distributed to the victims. See, suppose there is a dadagiri. He collects from many people crores of money, and if there are some real innocent people who are the real victims, till under the CRPC there is no provision for returning back the proceeds of crime. It will go to the state. Now there is a specific provision in section 107, that subsection 7, on receipt of 107 subsection 6 and 7. Noted, if the court or magistrate finds the attached or seized properties to be the proceeds of crime, the court or the magistrate shall by order direct the district magistrate to rateably distribute such proceeds of crime to the person who are affected by such crime. Then coming down, subsection 7. On receipt of an order passed under subsection, district magistrate shall, within a period of 60 days, distribute the proceeds of crime either by himself or authorize any subordinate officer to effect such distribution. So there is a provision for distributing the proceeds of crime to the victims also. Okay. Then section 109, power to impound document etc. produced. Any court may, if it thinks fit, impound any document or thing produced before it under this Sanhita. One question to my junior advocates and law college students are, can court impound any document? What about passport? Can court impound the passport? No or yes? Why? I told you an example of mother-in-law and daughter-in-law. Yes, my dear. Loud? Excellent, my dear. After this session, I will give you a kiss. Okay? Excellent. I love you. See, he has got the point rightly. What did he say? Special law. Passport is governed by Passport Act. This is the sharpness of an advocate. See, I gave a clue. Mother-in-law, father-in-law. Mother-in-law, daughter-in-law. He caught the point. General laws are like mother-in-law. Special laws? Which is more powerful, my dear? Special law. Yes. So, Suresh Nanda versus CBI. Suresh Nanda versus CBI. 2008 Supreme Court. Passport cannot be impounded by the court under general laws. Passport can be impounded by the authorities under section 10 of the Passport Act. Now, we will just make it fast. Section 129, no significant changes in that. Section 130, last lines, there is small correction. 130, last line. Number of sureties after considering the sufficiency and fitness of sureties. Previously it was character and class of sureties. These words were removed because nobody can know the character of anybody. So section 130, last lines, character and class of sureties removed. What is inserted? Sufficiency and fitness. Then section 145, which is equivalent to section 126 of CRPC. 145 subsection 1 small d. 145 subsection 1 small d included. What is included? Where his father or mother resides. To put it simply, 125 of CRPC spoke about, what is 125 of CRPC, my dear? Yes. What is 126 of CRPC? How to recover. In 126, a old parent, father or mother, who may have a decree in their favor, an order in their favor under 125, but if they want to realize it, they have to go to the place where the son is residing. They cannot realize it from their place of residence. Now, after 150 years, it was amended, so a father-in-law can sue a son and get an order of maintenance and also can collect the arrears from their place of residence. So this is a excellent provision for duty-less son, right? Duty forgotten son. Then coming to 148, subsection 2, 1, 2, 3, 4, fifth line, any person. Come to section 148, subsection 2, fifth line. What is the word used? Any person. Previously it was male person. How many of you think that this word is right? British people thought that unlawful assemblies can be dispersed only by male person. Now Parliament has inserted any person. Is it right or wrong? So women are capable of dispersing. Huh? Dispersing what? See, I will tell you one thing. Women alone are called as Shaktis. Right? Bharat Mata. She is only called as Parashakti. So they are better equipped to disperse any crowd. Any husband who comes to the family court says, "Sir, we were in a united family, sir. She came and dispersed the family itself, sir." Right? Taking cue from that only, I think Parliament has done this. Then, section 152, subsection 1, small c. 152, subsection 1, small c. That the construction of any building or the disposal of any substance as is likely to occasion conflagration or explosion should be prevented or stopped. Previously, this was not there. If the district magistrate thinks construction of the building will lead to any conflagration or firing, you need not go to the civil court. You can approach a district magistrate and can obtain an immediate remedy of stopping that nuisance. Come to 154, my dear. 154 subsection 8. 154 subsection B, 154 subsection B. Appearance in accordance with such order and show cause against the same and such appearance of hearing may be permitted through audio, video, electronic means. No? Come to 530. What 530 subsection 2 says? 530 subsection 2. Examination of complainant and witnesses. Then what 3 says? Recording of evidence in inquiry and trial. Then all appellate proceedings may be held in electronic mode by use of audio, by use of electronic communication or use of audio video electronic means. So section 530 is reflected in section 154. Any proceedings before an executive magistrate also can be held in, permitted in audio video means. So you need not go to the district magistrate's office also. Okay. Up to what time you want me? See, I told you I don't have any other business in Bangalore. Vivek Reddy ji called me for only for one business. What is that business? Finishing all the 3 laws. So if you want to remain, you can remain. I am there to finish. Okay. And suppose if you want to quit also, you can quit. You should think that it is a college. I am a college teacher. You are all students. If you want to quit also, you can quit. And if you want to sit also, you can sit. If you are going to sit.
You continue. 2 minutes will acknowledge thanks.
Yes, sir. Yes.
Not more than 2 minutes.
Yes. No, it's all not required. No, everybody sit. Oh, please. No, please.
Okay.
When is that?
Sir.
Every 3 to 4 months, we will call Chandru sir for a special speech. Every 3 to 4 months, to guide all of us and we thank him so much for devoting his time. ನಮ್ಮ ಯುವ ಪೀಳಿಗೆಗಾಗಿ, ನಮ್ಮ ವಕೀಲರಿಗಾಗಿ ಸಮಯ ಕೊಟ್ಟು ಇಷ್ಟು ಆಳವಾಗಿ ಈ ಒಂದು ಕಾನೂನುಗಳನ್ನು ವಿಮರ್ಶೆ ಮಾಡಿ ನಮ್ಮ ಮುಂದೆ ಇಟ್ಟಿದ್ದಾರೆ. ಅದು ಎಷ್ಟು ಸಿಂಪಲ್ಲಾಗಿ, ಎಷ್ಟು ನೀಟಾಗಿತ್ತು ಅಂತಂದರೆ, ನಿಜವಾಗ್ಲೂ ನಾವು ಕಲಿಯೋದು ಅಲ್ದಿರ ಬಹುಶಃ ಜಡ್ಜ್ಗಳು ಕಲಿಯಬೇಕಾಗತ್ತೆ ಇದನ್ನು. ಆದ್ದರಿಂದ ಸರ್, ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಅವರ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಅಸೋಸಿಯೇಷನ್, ಐ ಥ್ಯಾಂಕ್ ಯು. Your next speech should be at the City Civil Court. Here at magistrate courts, criminal law is practiced really. That is why we wanted you to. We have our sessions courts. Next event, within a short time I will get the date. The same speech you should make in the sessions court. And every 4 months we will call you. Tavelru, we are all permanent members of Chandru's fans. Thank you. Continues.
And Vivek Reddy sir and his team is making me to feel shy. And I want to confess, this is the first time somebody is putting a cap for me. Yes. And this is the first time somebody is putting a huge garland and all. I have seen only politicians in the screen having all this. And in that way, no, I am feeling very shy. Okay.
Our additional AGS. ಅಡಿಷ್ನಲ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಇಸ್ಮೇಲ್ ಅವರು ಬಂದಿದ್ದಾರೆ ಚಂದ್ರು ಸರ್ನ ನೋಡೋದಕ್ಕೆ. ಅವ್ರನ್ನ ನಾವು ಸ್ಪೆಷಲ್ ಗೆಸ್ಟಾಗಿ ಕರೆಸಿ ಅಭಿನಂದಿಸ್ತಾ ಇದ್ದೀವಿ.
We'll continue. Yes.
Miss you, sir. Actually, we are
Oh,
really we are missing you.
oh my God.
He said soon we will catch up with citizens.
Thank you.
Thank you.
Thank you so much. Thank you so much. Thank you for all love. Okay, now this next provision is section 157. I have told you in the morning itself that everything is time frame. The duty of every stakeholder is time frame. Everybody, even courts, no, judgment should be given in time frame. Investigation should be completed in time frame. Executive magistrate should finish their work in time frame. Like that, section 157 says, see the last provision, section 157, subsection 3, last provision. Go to 157, subsection 3, proviso. Provided that the proceedings under this section shall be completed as soon as possible within a period of 90 days, which may be extended for the reasons to be recorded in writing to 120 days. Now, the proceedings before an executive magistrate is also time frame. It is also time bound. Okay, my dear. Then come to 162. I have told in the morning, section 15 should be read with 162. You understand? Yes. What does this say? Magistrate may prohibit repetition or continuance of public nuisance. A district magistrate or subdivisional magistrate or any other executive magistrate or deputy commissioner of police empowered by the state government or the district magistrate in this behalf may order a person not to repeat or continue a public nuisance as defined in the Bharatiya Nyaya Sanhita or any other special law. So this is with regard to magistrate to prohibit repetition or continuation of public nuisance. Now come to 172. 173 is going to be very important because it is like our 154. Okay. Now it is 172. What is 172? It is persons bound to conform to lawful direction of police. Previously, this was provision section 168 to 179. I am repeating, section 168 to 171 was pari materia, section 149 to 152. 168 to 171 was pari materia with 149 to 152. New provision is 172. What is the provisions of 168 to 171? Preventive actions of police. That is, if the police suspects that there will be a cognizable offense, it is not only that after cognizance offense has taken place, police should come, arrest somebody and make a detention of the crime and detention of the person. Now, these provisions 168 to 171 says preventive actions of police. Right? In this preventive action of police, 172 says persons bound to conform to lawful directions of police. In that course, if police makes certain preventive actions and somebody is intruding on that, such persons can be arrested. They can be detained for a period of they cannot be detained for more than a period of 24 hours. This is a new provision included in the BNSS. Now come to section 173. This is very, very important. For any criminal lawyer sitting here, 173 is very important because it is like our 154 of CRPC. What is 154, my dear? FIR. Now, what are the new things in 173 of BNSS? One is zero FIR. I will tell you simply what is zero FIR. Now I am in Bangalore. Okay, my mother calls me. She is a sick person. We will imagine that my mother is healthy only, for an example. She is a sick person calling from me that somebody has stolen something from her house. But for my number, she cannot contact anything else. There are certain people who can call only 1 or 2 numbers. No. Now I am in Bangalore. I have to move the law into motion. I cannot immediately go to Chennai now. Now zero FIR is a concept introduced in BNSS, that is registration of a cognizable offense information to a non-jurisdictional police station. I am repeating, my dear. General lawyers, FIR can be registered only in the jurisdictional police station where the crime takes place. Zero FIR is something where a report on or an information on a cognizable offense can be lodged in a non-jurisdictional police station anywhere in the country. Ji? Inter-district, inter-state. Yes. What is the advantage? What is the disadvantage? What is the advantage? There are still small villages, small places where community fights goes on, where a mighty fellow will assault a lesser mighty or a meek fellow. And after getting the injuries also, you cannot go to that station to set the law into motion, because that mightier fellow will be knowing that he will come to this station, I will see how he is coming. Right? We do not understand the practical things. There are so many people who are still in a very weak position. So, in a way that anywhere, as he rightly said, anywhere anybody can kick in an investigation. Can kick in an investigation. So, zero FIR is one concept introduced in section 173. But if you search for the word zero, it will not be there. What do they say? 173, second line. Yes, 173 subsection 1 says, every information relating to the commission of an offense, of a cognizable offense, irrespective of the area where the offense is committed, may be given orally. Then second introduction, or by electronic communication. I told you that setting the law into motion or going to a police station and getting registered an FIR is one of the greatest headaches even now. Right? You go to police station for the purpose of registration of FIR. The first thing what they will say is, SHO has went on a duty. Inspector has went for SP's office. Right? Minister has come. Prime Minister has come. They will say so many reasons. Prime Minister would never have come to Bangalore. He will be in Delhi. They will say some reasons, one or the other. And if they make you to walk for 5 to 6 days, what you will do? You will think that the injury is better than the process. So you will not go. Now this is one another welcome move by this government, that you can register electronic FIR to the website of the police station. What should be the duty of the policeman after that? If a cognizable offense information is received, you should start the investigation. Right? We were discussing about 2 signatures in the morning. What are the 2 signatures? Yes. Now, if you send an information, that is the first information, to the police station without even signing, law says you have got 3 days to go and sign. Now, there are certain SOPs released by the Home Ministry. I will share it to Rajan also. I will share all the 180 judgments to Rajan, and also Rajan can share. You all have a group in this. You can have one group, new criminal law group. Whoever has attended, no, I am not joking. Whoever has attended, you can form one group called as new criminal laws group. In that you can share this thing, all purposeful law relating things. Right? And I will give it to my friend Rajan. I will give all the judgments, and the SOPs also I will share. Home Ministry has given certain SOPs. In that it says, if you lodge an FIR by way of an electronic communication, and after that if you don't sign within 15 days, police will remove it from the site. Why? Why, my dear? Reason. See, I have lodged electronic FIR. Law says I should sign it within 3 days. If I am happily sitting without signing means, it is not valid. See, I will be thinking, what is it, let it go off. That's all. I am not serious. So SOP says after 15 days it will be removed from the site. So I will share the SOP also. Please read the SOP. Okay. They will not prosecute, Ji. You read the SOP, I will share the SOP. Then 173 subsection 2. This is also one of the nice advantages, right? 173 subsection 2. Copy of information as recorded under subsection 1 shall be given forthwith free of cost to the informant or the victim. Previously it will be given only to the informant. Now it is given to the victim. Now coming to subsection 3, which is also a new provision. Right? Before going to that, I will give you some judgments with regard to FIR. What is the famous judgment under 154 CRPC? Excellent. Write that judgment. Lalita Kumari versus Government of UP, 2013 and 2014. Then State of Telangana versus Managi Pet, Managi M-A-N-A-G-I-P-T, Managi Pet alias Mangi Pet, 2019 Supreme Court. If you want to know something about zero FIR, you should read Neelu Srivatsav versus State NCT Delhi 2021 Delhi High Court. Neelu Srivatsav versus State represented by State NCT Delhi 2021 Delhi High Court. Then NCT Delhi 2021. Then State of AP versus Punnatti Ramulu. State of AP versus Punnatti Ramulu. Then Satwinder Kaur versus State of Punjab. Satwinder Kaur versus State NCT Delhi. Satwinder Kaur versus NCT Delhi. These two judgments, this Punnatti Ramulu and Satwinder Kaur judgments, relate to if a FIR is registered in a non-jurisdictional police station, how it should be dealt with, where it should be sent. Okay, for that you read that. Come to 173 subsection 3. It says, if an offence is punishable for 3 years, I am repeating, 173 subsection 3 says, if an offence is punishable for 3 years and less than 7 years, then the police can make a preliminary inquiry before registering FIR. This is one deviation from main provision 173 subsection 1. But it should be done only after getting permission of a DSP. Okay. However, they can proceed with investigation when there exists a prima facie case. This is one new addition, provision subsection 3 of 173. 173 subsection 4 speaks of, I will ask you a question. Law college students can answer. You go to a police station for registration of FIR. Station house officer doesn't register. What you will do? You write a letter along with the information which you have given. You send it in an RPAD, registered post with AD. That was spoken of in 154 subsection 3 of CRPC. Now it is 173 subsection 4. Another difference is, in previous CRPC, if you lodge a FIR, station house officer doesn't receive it, you write a letter to SP. The SP, what he will do, he will insist the station house officer once again to investigate. Now a deviation is made. Now the present law says, 173 subsection 4 says, the SP himself investigated or appoint any other officer. You understand, my dear? Not the same fellow. See, I am not satisfied with that fellow. That fellow has not registered the FIR. So I am going to the SP. If the SP sends me to the very same person, what he will do? Oh, now you are back with me. Yes, I will do what I will do. So this one another good provision is in section 173 subsection 4. Okay. SP is also non-reactive, non-responsive. Where should we go? Go to the magistrate. This was under 156.3. 156.3, which is called as application to magistrate. It is not a private complaint. See, if it is a private complaint, it is section 200 of CRPC, which is presently 223 of BNSS. 200 of CRPC is equivalent to 223 of BNSS. Right? Now, 175.4 itself says, see the last lines. 175.4 itself says, such aggrieved person may make an application to the magistrate. You understand, my dear? 175.4.3 subsection 4 last lines. Aggrieved person may make an application to the magistrate. Along with that, you should read also section 175 subsection 3. I am telling you once again, 173 subsection 4 last lines, application to magistrate, should be read with 175 subsection 3. That is That also speaks of application to magistrate. This 175.3 is equivalent to 156.3. Okay? 175 subsection 3 is equivalent to 156 subsection 3. Next comes section 174. 174 subsection 1 Roman 2. 174 subsection 1 Roman 2. What does it say? It speaks of non-cognizable offences. There are two types of offences. One is non-cognizable, another is cognizable. If it is a cognizable offence, police is duty bound to register FIR. If it is a non-cognizable offence, a person goes to the police station, the police will say, we will write it in a register and they will refer the informant to the magistrate. Only the magistrate should order for registration of FIR. This was the previous law under section 155 of CRPC. Now 174 says, forward the daily diary report of all such cases fortnightly to the magistrate. That is, any person who approaches the police station with a non-cognizable offence, a police is duty bound to register it in a diary, and that diary also should be sent to the magistrate court in every 15 days. It means the court also will supervise that register to clarify itself whether the police is making some gimmicks in making a cognizable case into non-cognizable, and they are refraining from registering FIR. So in this way also, citizens are protected and court is mandated to supervise. You understand? Yes. Come to section 175. 175 speaks about investigation. Who will investigate a case normally, my dear? Police. Which police? Jurisdictional police. Who investigates in that? Station house officer. We will call him as station house officer. Okay. Whether DSP will investigate a case? Yes. When? Special offences only DSP will examine, will investigate. Under CRPC, only with regard to special offences, DSP will investigate. Now this is called as Nagarik Suraksha Sanhita. It has given an introduction in section 175 subsection 1 proviso, which says any case, any nature of case can be examined, can be investigated by a DSP if the SP feels so. Yes. So if the superintendent of police thinks that this is a case where station house officer should not investigate, a superior rank officer should investigate, then without any difficulty an SP can order him. Previously it requires special sanction and all, permission and all, it should go up to the DGP. Nobody can do like that. So this is also one of the good facets or important facets of BNSS, that any offence of any nature, taking into consideration the gravity, the SP can ask a DSP can examine. This is one good thing. Then 175 subsection 3, I have told you, it is like our 156 subsection 3. This is for my law college students and young criminal lawyers. A person I go to the police station for registration of FIR. Okay. I am called as the informant. If police doesn't register, I am called as the failed informant. I attempt in registering an FIR. I cannot. I am called as the failed informant. Right? I want to file a case as against an accused. That accused was not made as an accused on paper. So he is called as a proposed accused. You understand, my dear? Two things. Failed informant on a proposed accused. Now, after taking all these procedures of going to SP and all, finally, if SP is also sleeping like the station house officer, what this man will do under 175 subsection 3 an application has to be given to the magistrate. What are the prerequisites? You should show to the magistrate that this is the piece of paper, information which contains cognizable offence, which I attempted or which I gave to the station house officer. Station house officer doesn't receive that. Thereafter, this is the registered post AD where I have given this information and a covering letter. This is the letter sent to the SP. This is the acknowledgement card of the SP. Yes. Then what happens? The magistrate, you should give an application to the magistrate. I am using the word consciously that it is an application. It is not a private complaint. Because if it is a private complaint under section 200 CRPC, which is equivalent to 223 of BNSS, then sworn statement is there, taking cognizance is there, recording of sworn statement is there, then only next processes will move on. In a 156.3 application, there is, but for application of mind on that, magistrate is not duty bound to examine the informant in the box. So it is not a complaint or it is not a private complaint. Okay? It is only a mere application. What happens? Many fraudulent informants, failed informants, they want to have their vindictiveness as against so many good people. They attempted to file lot of false private complaints on the one hand, and whenever the police is reluctant in recording FIRs which are not worth of recording, sometimes the police knows that it is a false information. They don't record. They don't register it as an FIR. Now what happens? These people go to the court under 156.3, which is pari-materia with 175.3, and get an FIR registered. In Priyanka Srivatsava versus State of UP 2014, Priyanka Srivatsava versus State of UP 2014, the Supreme Court mandated for filing of an affidavit along with the 156.3 application.
Detailed affidavit.
Yes, detailed affidavit. That is to bind himself in the future. Priyanka Srivatsava versus State of UP 2014 Supreme Court. Okay?
Otherwise, magistrate has got the powers to reject the application.
Yes. It will be dismissed, that application. Now, this dictum of Priyanka Srivatsava of 2014 was made as a law in 175 subsection 3. See the second line, 175 subsection 3 second line. Any magistrate empowered under section 210 may, after considering the application, supported by an, yes, this was the affidavit insisted by Priyanka Srivatsava, which was made by the parliament as a law. Please underline that. Then another important thing is public servants are protected under BNSS. Two important provisions is 175 subsection 4. Underline that. Read this with 223 subsection 2. I am repeating, 175 subsection 4 should be read with 223 subsection 2. These two provisions are greater provisions in the interest of a public servant discharging a public duty from being harassed. What is important? Public servant discharging public duty. It is not protecting all the public servants. A public servant who is a doctor, right, committing rape on a patient, is it his discharging duty? No. A police inspector receiving corruption, is it discharging public duty? It is not discharging public duty. So now BNSS protects public servants who are discharging public duty from being harassed by way of private complaints under 223 subsection 2 and also by way of application to magistrates under what provision? 175 subsection 4. What does it say? I will tell you one example. This Priyanka Srivatsav case. Why Supreme Court got irritated in that case? No. In this Priyanka Srivatsav case, a bank manager was harassed for 20 years on a private complaint. Who gave the private complaint? The person who took the loan. Loanee. We will be happy when we receive the loan. But the greatest sin a bank manager should not commit is, bank manager should not commit 2 sins in his life. First of all, he should not give loan. Greater sin, Rajan says the right thing. He should not ask us to repay. If the manager asks us to repay, he commits a greater sin or the greatest sin. That was exactly happened in Priyanka. Manager asked the loanee to repay. This man started giving private complaints for 20 years and killed the man. Yes. Supreme Court said all this is enough. Now law says 175(4) and 223(2) says any complaint on any public servant in discharging their duty, court should not order for registration of FIR, or court should not take cognizance on the complaint. Prior to that, court will ask the public servant to appear before, court will ask him the explanation. Are Baba, please come. Are you a public servant? Yes. Are you discharging the duty in a public servant as a public servant? Yes. Why this man is complaining as against you? This public servant, before becoming an accused in an FIR, now will have an opportunity to at least speak. I am reserving 2 for you. Public servant, see, he is catching the point very nicely. Suppose a junior is a good public servant, honest public servant. On the top of him is a senior, very dishonest man. Now what this dishonest man will come and do? What report he will give? He will give a false report. But law always presumes that people are good. Law always presumes that things will happen nicely only. Law will presume that things will happen legally. Now there is a protection to public servant. He will be heard. His senior will give a report as to in what discharge of duty some person is aggrieved and he is filing a false case. Okay? Yes. These are all important aspects, Ji.
Sir, it says receiving the report containing facts and circumstances of the incident from officer superior to him. So the magistrate may not write to his immediate senior. He may refer it to, if it is an inspector, he may refer it to one level above, skip level.
You should be the magistrate then. The accused who is present, cannot say you take it from this man. It is an officer superior. It is generally believed that they will not see. Suppose if an inspector does something, they will normally ask it only with the DSP. They will not ask DGP for that to come. Gee, you are not a government servant. You do not know how many politics are there. And it is very difficult to be a good person. And to be a honest person is also very difficult. Things are getting recorded. In spite of that, I am talking too much. You want me to talk more?
Again, 4B is vague. Assertions made by the public servant to whom? Whether to the court, whether to the magistrate or to its
To the court, to the court, to the court, to the court. Okay, now you will come to section 227. Oh, we will come to 223 1 second. Gee, we have already finished. Oh, now we are in 175. Okay. Now come to 176. Subsection 1, last proviso. 176, subsection 1, last proviso. What does it say? Provided further ... through any audio, video, electronic means including mobile phone. So in investigation also, audio video is introduced now through a mobile phone. Okay. 176.3, we have already dealt now, my dear. 176 subsection 3. What is 176 subsection 3? Visiting the crime scene by? Yes, forensic team, excellent. Yes, 176 we have already seen. 179, what is the new addition is? 179 is equivalent to section 160 of CRPC. 179 of BNSS is equivalent to section 160 of CRPC. It is police summoning a person for the purpose of recording 161 statements. Previously, you cannot summon a male child below 15. You cannot summon any woman. Right? You cannot summon a person above 60 years. Now, what law says, it has included one more addition, that acute illness. Now you cannot summon a person with acute illness also, along with the three categories. Right? Then see the proviso. Provided further that if such person is willing to attend at the police station, such person may be permitted to do so. Previously it was said police should not call at all. Now one addition has come. What it is? Whether this will be misused or used? But some people told me, see, there are two ways of seeing a thing. Some people in some academy told me, women will not like policemen to come to the house. And surrounding people will think that there is something in this house, police are coming and going. In that score, they are telling that, no, we will come to the police station. See, things has to be seen different ways. I told you, you should remember surgeon's knife. Can be used for surgery or for murder. We will pray God that surgeon's knife is used only for surgery. That's all. Come to 183. Subsection 6. Subsection 6 small a. Come down to proviso. Now, in proviso, one addition is, whenever a woman or a child is sexually assaulted, then that child should be, the statement of that child should be recorded by the magistrate, and that statement shall be used as a chief examination if the court finds that that child is temporarily, permanently, physically or mentally disabled. This was from the law of Shivanna. Supreme Court in State of Karnataka by Nonna Vinakiri, State of Karnataka by Nonna Vinakere versus Shivanna alias Tarkari Shivanna. Nonna Vinakere. Okay. After 2 or 3 times I will read Kannadaji. Versus Shivanna alias Tarkari Shivanna. 2014 Supreme Court. State of Karnataka by Nonna Vinakere versus Shivanna alias Tarkari Shivanna. 2014 Supreme Court. Now there is another additional mandate that magistrate shall record 164 statement in cases where the offences are punishable with imprisonment for 10 years or more also. This is one additional requirement along with sexual offences. Then this recording of 164 statements should be done by audio video means, preferably by a mobile phone. This is also one another proviso. 184 we have already grouped it under. 184 we have grouped it under 51, 52, yes. Then come to section 185. Search by police officer. Come to subsection 2. Come down. Provided that search conducted under this section shall be recorded through audio video electronic means, preferably by mobile phone. We were seeing about search and seizure, section 105, should be done by audio video mobile phones. No, now it is with regard to search by police officer, even that it shall be recorded through audio video means. Now police cannot write stories that yes, we have conducted search, we have seized things, everything should be, there should be audio video electronic record for that. Come down to subsection 5, 185 subsection 5. Such records should reach court not later than 48 hours. You found that? 185 subsection 5, second line.
Shall reach.
Yes, shall reach. Not later than. That is 48 hours is upper time limit. Then 187. This 187 is like our 167 of CRPC. This speaks about two things. 187 BNSS is like our 167. This is very important, and there is a lot of confusion, and many people, even judges, advocates, they are giving interviews in TVs. I say with all humbleness that they are talking wrongly on 187. They are not reading the provision properly. Right? To criticize the new laws under BNSS, I had found that even well-read persons, they are bluffing on this. What is 187? 187 was like our 167 of CRPC. What is 167? 167 says that a magistrate or court cannot remand a person more than a period of 60 days, that is beyond a period of 60 days, if the charge sheet has to be filed within 60 days for offences which are punishable below 10 years. If offences are punishable for a minimum period of 10 years and above, charge sheet should be filed within 90 days. Failing which, or default in this class by the investigating agency will lead to a bail called as default bail, or statutory bail, or mandatory bail. Okay, this is one portion of section 167, which is like our 187. What is the second portion? Second portion is, see, I have told you one thing, right to life of the accused is one thing, and one victim's right to life and personal liberty was already damaged. That lady or man is sitting in the house and crying, thinking that I have entrusted the case to the state, now state will take care of everything. Investigating agency has got a duty to properly investigate the case. In that process of investigation, they will also ask for police custody of the accused. You understand, my dear? Yes. In India, there are only two types of custodies. One is police custody, another is judicial custody. Is under whose care? Judge. Where it takes place? Jail. Judicial custody is in jail under the judge's care. Police custody is in the police station. You understand this much? Yes. Now, in every investigation, police has a right to ask for police custody. If police makes out a case, police will say, without this person's investigation, without this person being taken into custody, investigation will not proceed any further. If the court is satisfied, then court can give police custody for a period of 15 days in parts. When it should start? It should start from the first date of remand, and it should end within the 15 days inclusive of the first date of remand and the last 15 days. You understand, my dear? Any doubt in this? It should start not from the first date of arrest.
From the date of remand.
First date of remand. Suppose Chandru is getting arrested today. They are taking Chandru to Jammu Kashmir in a bullock cart. How many days will...
20 days.
In the way there are deaths of the bullocks or Chandru. Right? So date of arrest will not be calculated. Date of remand will be calculated on the first date of remand. Suppose Chandru is remanded on 1st January. 1st January will also be counted and 15th January will also be counted. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Full 15 days. Both days will be counted. This is from date of remand. Now, this law, this proposition was made by the Honorable Supreme Court in CBI versus Anupam Kulkarni in 1992. CBI versus Anupam Kulkarni in 1992. Enna Rajan Talavaliya? CBI versus Anupam Kulkarni 1992. This judgment of CBI versus Anupam Kulkarni was confirmed. This is a division bench. What is a division bench, my dear? How many judges? Huh? 2. Full bench? Full bench 3. Constitutional bench is minimum 5 or more. The word is minimum 5 or more. Minimum 5 or more. So he is right, sir is right. Here, because in Supreme Court only you should call it as a constitutional bench. Minimum 5 or more. In High Court it is a specially constituted bench of any number. If it is a full bench, it is 3 judges. Okay. This CBI versus Anupam Kulkarni of 1992 got its stamp by the Honorable Supreme Court in a full bench judgment in Budh Singh versus State of Punjab. Budh Singh, B-U-D-H, Budh Singh versus State of Punjab in 2000. That means the law in this country is police custody shall be given only within the first 15 days of remand and not beyond that. He can be in judicial custody for 60 days or 90 days, depending upon the 10 years punishment or more than 10 years, right? Our people, especially highly placed politicians, right? In many cases, what they have done is, because they have got good defense lawyers, no, like us around, they will now say, you should not get caught with the police. First date of arrest, you should act. Heart patient. Any politician you arrest, he will have an heart attack. Otherwise, you give mic to a politician, he will talk better than me. Right? Any person you arrest, no, immediately he or she will become sick and they will be taken to government hospital. Within no minute from government hospital, they will go to super speciality. Now, what has happened? All these dramas are going on for a very long time because they want to evade that first 15 days. After first 15 days, where they will go? Judicial custody, jail, police custody, there are chances of torturing. Right? They want to avoid that. What has happened? Supreme Court took note of this in 2 cases. CBI versus Vikas Mishra, CBI versus Vikas Mishra, 2023, and V. Santil Balaji versus state represented by DDED, Deputy Director, Enforcement Directorate, 2023, Supreme Court. CBI versus Vikas Mishra, 2023, Supreme Court. And after that, V. Santil Balaji versus State represented by DD, Deputy Director, ED, Enforcement Directorate, 2023. Supreme Court said, All this business are not going to work. Which business? 15 days work. Regarding police custody, Supreme Court said Anupam Kulkarni has to be revisited and police custody should be given for 15 days within 60 days or 90 days. They said we are not going to restrict police custody for the first 15 days alone. See, Supreme Court says you are in police jail custody now for 60 days. Within that jail custody 60 days, police can take you for police custody on any 15 days.
Whenever you want.
Huh?
Whenever you want.
Yes, because he has got a right to investigate within that 60 days. If it is an offense which is punishable for 10 years and above, police can take you for police custody within 90 days. See, I am repeating, it is only for 15 days. Police custody will not be given for 60 or 90. It is only 15, but not within that first 15. As laid down in Anupam Kulkarni. Now Parliament, and this Sandil Balaji's case, Supreme Court referred it to a larger bench.
So one clarification here. Suppose the investigation officer comes for taking the police custody for any aspect person. So you want to take a 5 days. Again he remanded to judicial custody. Then only after 15 days he came again. Then only he want to fully take
Yes,
5
yes,
days.
yes. I said, I used the words parts, in parts, right? Now what has happened, this was the law before, this was the Supreme Court's verdict on police custody. Parliament, what happened, Supreme Court said 60-90. Parliament reduced that 60 into 40, reduced that 90 into 60. You understand, my dear? I will tell you once again, previously it was only police custody can be given only in the first 15 days from the date of remand under 167 of CRPC. Supreme Court said this is a wrong interpretation. They said police custody can be taken within the entire 60 days or entire 90 days to a limited period of 15 days. Now Parliament says, law says 187 says, no, 60 days is too much, 90 is too much. 60 they are reducing into 40, 90 they are reducing into 60. But in no count, police custody should exceed 15 days. Please remember, police custody is not for 40 days. Police custody is not for 60 days. Police custody is only for 15 days within that 40 or within that 60. Understand, my dear? Yes. This is what is section 187. Come to 187, come to subsection 5, last proviso. 187, subsection 5, last proviso. This is also very interesting. What it says, provided that no person shall be detained otherwise than in police station under police custody or in prison under judicial custody or a place declared as prison by the central government or the state government. What do you understand from this? 187 subsection 5 proviso. It says a person can be remanded either in police custody in police station or in judicial custody in prison or a place declared as a prison by the central or state government. That means one judgment was given by the Honorable Supreme Court in Naulaka, Gautam Naulaka versus NIA. 2019 Supreme Court full bench. Gautam Naulaka versus NIA. Supreme Court. In Gautam Naulaka versus NIA, Supreme Court said there are 3 custodies. One is police custody, one is judicial custody, another is house custody. Then Supreme Court also said any magistrate can also remand a person to his own house custody. Imagine a situation, if this judgment of the Supreme Court is followed, any influential fellow, where he will sit? House surrounded with more security also now. Because his inside police will be around his house, he will be enjoying more a VVIP status. Now law says there are only two custodies in the country. One is police custody, another is judicial custody. Or if you want to stay in your house should be declared as prison. This is a good thing, no? This is called as Nagarik Suraksha Sanhita. Yes, see, nobody is above law. Will any of our VVIP will want his house to be declared as a prison? If the house is declared as a prison, another difficulty is his other brothers will also come to his house. Which brothers? Criminals. If your house is declared as a prison, then it will be thrown open for everybody. If the real prison is loaded, then people will come and stay. So this is one another thing. Now Gautam Naulaka judgment should not be followed because of this.
What about the police protection?
For whom, sir?
This law. If the home arrested is ordered.
How it will be ordered? Now it cannot be. There are only two custodies. Yes. Yes. I told about Siddharth versus State of UP, one judgment. No, my dear. I told two provisions. Section 170 of CRPC equivalent to Section 190 of BNS. Right? You remember? Rajan, another doubt? Ji? Any doubt? Tell me. I am your friend. I am not your teacher. You can tell me. Section 190. What does it speak about? 190 says cases to be sent to magistrate when evidence is sufficient. Right? In this only I spoke about Siddharth versus State of UP. There are certain cases where charge sheet will be filed immediately. That is traffic offences. What they will do? They will just stop you, give a challan. These are all cases governed under 190. In that, law says you need not arrest the person. That arrested person need not be produced with the charge sheet, and he need not also pray for bail. Please read Siddharth versus State of UP. Then come to 193G, which is very important, equivalent to Section 173.
Says magistrate should not mechanically arrest if he is not arrested, but you should give adequate time for him to apply for bail.
Yes, Ji. There is no dispute in that point. Very correct. Section 193 speaks of charge sheet. 193 BNSS is equivalent to 173 of CRPC. What are the new things in that? Now police need any investigating agency will not bring huge heaps in the cart. CBI cases, have you seen? They will bring records in truck. 1,000 documents, 2,000 documents, 500 witnesses. One advantage for accused is in CBI cases. What advantage? 500 witness, 2,000 documents. Accused will meet the maker. Either the accused or witnesses will go to heaven. Trial will take 10 years, Ji. Right? I argued a case before Madras High Court in a CBI case. Right? Because the advocates who are appointed on behalf, the advocates who appeared on behalf of the accused, they doesn't turn up. It came up before Honorable Justice Chandru. He has removed the wakalat and appointed legal aid counsel. So legal aid has appointed me as advocates. 3 cases, voluminous cases, right? It took nearly 1 week for me to read the 3 bundles. Almost 350 documents, right? 40 witnesses in each case. I argued the entire case only for 3 minutes. You believe that? Only 3 minutes. I argued the case only for 3 minutes, having read for 1 week. just 3 minutes, I relied upon 2 exhibits out of 300 exhibits. I relied only 2. Criminal appeal. Only 2 documents. I said, my lords, there are 300 judgments. I will take you only to 2 documents. I will take only out of 40 witnesses, I will take you only to 4 to 5 witnesses. I got an acquittal in that. See, an intelligent advocate will know where a case stands. Like that, if the prosecuting agencies are also very intelligent, they will not heap all this dust. Out of 300 documents, I felt that 298 documents are irrelevant. It is all irrelevant. There is no need for the court to just look into that. So the investigating agency should be very sharp in finding what is the offense. Where does it stands? Which is the witness who is going to prove? Which is the document which is substantiating the evidence? That's all. If intelligence agencies are also very intelligent, then they will really have a conviction or acquittal. Or else it is all waste of time of court. Now 193, which is pari materia with 173, speaks of 2 things. One is charge sheets will be filed by electronic means, point 1. You may not have you cannot fight with the judge. Copies are not proper, because that is one technique of taking adjournments, no? Free copies are inadequate, then Xerox copy is not proper, some pages are missing. So from 1/7/2024, our younger generation will not have all this advantage which he enjoyed. Just refer the email, that's all. All will come with the press of a button. What we enjoyed, unfortunately, you cannot enjoy. What to do? You will find some other new techniques of getting adjournments. Then, come to 193 subsection 2. It says, what is section 64 to 71 BNS, my dear? BNS. I said, the law minister said all the laws were, women regarding laws and all were given preference. See, rape, excellent ma. 64 to 71 is offences relating to rape. Now BNS's subsection 2 says offences regarding rape and POCSO, charge sheet has to be filed within 2 months. Right? My question, am I right? Shankar, read this ma, 193 subsection 2. You are the most energetic man in this team.
The investigation in relation to an offence under section 64, 65, 66, 67, 68, 70, 71 of the Bharatiya Nyaya Samhita 2023 are under sections 4, 6, 8 or section 10 of the protection of children from sexual
Yes, shall be completed within 2 months from the date on which the information was recorded by the officer in charge of the police station. I told you, when we were discussing section 187, I told you one thing. If charge sheet is not filed in time, that person will get a bail which is called as? My question is, now 193 subsection 2 says, charge sheet should be filed for rape offences and POCSO within 2 months. If it is not filed within 2 months, can you go to the court and ask for a default bill? You understand? 193 subsection 2, it says you file charge sheet within 2 months. If police officer doesn't file, enna Rajan, kekalama? Yeah? No better answer. Yes, ma?
The punishment is above not less than 10 years. It is mandatory project to 90 days to file the charge sheet. But here is within 2 months. The 30 days, 1 month time is there, no? That's why.
But here there is another one provision, no sir, after 187. This says you file charge sheet within 2 months.
I think that is not entitled to
Why? Reason. You are right, but reason. He is also right. Rajan is also right. You are also right. Reason.
Reason is the 20 days was there.
Which law? They say you should file charge sheet within 2 months. If charge sheet is not, my question is, if charge sheet is not filed within 2 months, as mandated under 193 subsection 2, can the accused use this default for invoking a default bail? Why?
Subject to the provisions of those two acts.
So what? See, simple. Simple. This provision is not a provision in relation to default bail. 187 is a provision which gives the right of default bail. This is a provision relating to filing charge sheet. This is an assignment given to the station house of the investigating officer to do. Failure will lead to dereliction of duty, that's all. Failure will, this is an assignment or a direction given to him. On the contrary, 187 says, if you do not do that, that person is entitled for bail. Such an entitlement is not stated in this. You understand, my dear? Why I am telling is, we should not mislead the court on this. If you are a prosecutor or a defense lawyer, court should not be misled. That is not our business. If the policeman or the investigating agency does not file it in time, you can always ask the court to take action as against that person. It is dereliction of duty. This will not entail you for a default bail because there is no provision for default and default bail here. Yes, sir. Excellent, sir.
Can a magistrate refuse to take cognizance if it is filed beyond 60 or 90 days? He has to.
Cannot. He has to. See, these are all not provisions relating to limitation. These are all not provisions relating to law of limitation. I will tell you one thing. In Tamil Nadu, two beautiful events took place. One is in case of SETTU versus SETTU, S-E-T-T-U, State 2 versus SETTU versus State represented by Inspector of Police 2020. You read that judgment, beautiful judgment by Honorable Justice G.R. Swaminathan. SETTU versus State represented by Inspector of Police. Judgment was delivered by Madras High Court, Madurai bench. As you have got here, no, Dharwad bench and other benches. That is Madras, High Court of Madras, Madurai bench. Justice G.R. Swaminathan. Supreme Court has said that we are extending period of limitation. You know that. Supreme Court during COVID time they said we are raising all limitation. So they have given almost 2 years limitation period for every act. In SETTU versus State, one man has approached the magistrate for default bail. Default bail was not granted. Question before Honorable Justice G.R. Swaminathan was whether limitation condoned by the Supreme Court is applicable for 167 CRPC also. Honorable Justice G.R. Swaminathan said, in all other limitations, if that person comes beyond the period of limitation, he will file an application under Section 5 of the Limitation Act. Yes. Because he will say 30 days was prescribed, 60 days was prescribed, 3-year time was prescribed. Now I cannot approach the court. You condone the delay under Section 5. Here, under 167, law says only 2 things. If you doesn't file it within 60 days or 90 days, I will not have the power to remand. So that default I will release on bail. That's all. Imagine, he has asked a very rightful question. Imagine whether in any history of investigation or police or criminal court, whether any policeman who has come with a charge sheet after 2 years, 3 years, 5 years, whether any policeman has come with a 5 limitation application. Why?
Up to 3 years they have power to file a charge sheet.
No, Ji, whether anybody has come with an application under Section 5, that is, no limitation is prescribed. It is a default. Code says you should do. Law says you should do. If you default, I will not have the power to remand. So 167 is basically power of remand and impotency to remand beyond a certain period. That's all. This is in Setu versus State. What happened thereafter? Kasi versus State, KASI versus State. This went up to Supreme Court. Right? State, represented by Inspector of Police, Chennai. What happened in Kasi versus State? Another one single judge, Honorable Judge of the Madras High Court, took a different view. He said the condonation delay of the Supreme Court is also applicable to section 167 also. So, police officer need not file the charge sheet within the prescribed time. Accused cannot now invoke default bail. This was made in Kasi versus State. This judgment went up to the Honorable Supreme Court. Supreme Court said the view of the single judge is erroneous, wrong. Supreme Court has upheld the law laid down by the Honorable Judge in Setu versus State.
Sir, but this judgment take notice of the Setu case.
Which judgment?
Both are single judges.
Yes.
So one more judge in Setu has already given a judgment. It should have been referred to division bench.
Excellent. This point was taken note by the Supreme Court, and Supreme Court condemned the subsequent judge and said it is indiscipline, judicial indiscipline.
Sir, again, 193, though it uses the word shall, again it is a question of interpretation whether shall is directly or mandatory.
How do you say like that?
Sir, many times I've read cases pertaining to IBC. Wherever shall has been used, sir, there also IBC is time sensitive. Sometimes it is not possible to, stick to the timeline. There Supreme Court has given the interpretation, although shall was used, shall is not mandatory, it is directly.
If at all, shall is followed by a consequence, a punishment, a consequence, then shall is mandatory. If shall doesn't have a consequence in that, then it becomes discretionary. Sometimes may will become shall. I will tell, because he has asked that. Sometimes may will become shall. In CBI versus Master Bolu, 2020 judgment, Supreme Court, CBI versus Master Bolu, BHOLU. Interpreting section 15 subsection 1 of Juvenile Justice Act. Interpreting section 15 subsection 1 of Juvenile Justice Act. Honorable Supreme Court in 15, what is section 15? Preliminary assessment of a child to find out whether the child is a child or the child has a maturity of an adult. This is what is section 15 subsection 1 of Juvenile Justice Act. Right? In that 15 subsection 1 says, while examining, the board may also take the assistance of a psychologist. May also take the assistance of a psychologist. Now what has happened in Bolu's case, a second standard child, his throat was slitted in the bathroom by a 11th standard boy. This child died in a school. A second standard child, his throat was slitted by a blade. That child bleeded and he died in the bathroom of a school. And as usual, police, they arrested the driver, the sweeper, because I have told in the afternoon itself, they know some astrology, astronomy. They will have some gut feeling. They should definitely proceed on proper evidence. They will have their own suspicions. Poor sweeper, poor peons, they were arrested, and finally the cat was out of the bag. It is a 11th standard fellow, student, has done that. Now that 11th standard student, unfortunately, he is not like me, thinny, bony and puny. He was too tall, dark, well built. He was looking like an adult man. Our assessors, they have written that this boy is looking like an adult. This is the test in India. Preliminary assessment is to assess the mental and physical capacity of the child. What are the tests? Whether this child has understood the nature of the crime, whether the consequences, not consequence. A child will know if it takes a knife and put it in somebody, it will bleed. But the child will not know that he will die, his family will be miserable. Consequences are not known to the children's mind. Right? Now, the assessors write, he is well grown, built up, more grown than his age. We presume him as an adult. Supreme Court says, law says, the board may have a psychologist, because psychologist is very, very important in that. That may has to be read as shall, failing which irreparable social consequences will heap upon the child. The child will be treated as an adult and he may face a life imprisonment also. You understand, my dear? Coming to shall, treated as may. In Salem Advocate Bar Association case, 2005 G, Salem Advocate Bar Association versus Union of India. Right? 2005, regarding CPC amendment. In Tamil Nadu, we had a long strike. When I was a small boy in 1990s, I became an advocate in 97. 99, we had a nice strike. I am using the word nice strike. Because when I was very small, I enjoyed that. But I don't have the mentality now. Now I am thinking that it is a big crime. We are wasting public money, we are wasting the resources of the court, and people are crying for justice. We have no right to go on strike or boycott now. We are the agents of the clients, that's all. What right we have got to go on a boycott? Right? But my place in Tamil Nadu, we went on a boycott in 99 also and 2002 also. Then we filed a case. Our main grievance is, they told that return statement should be filed within 30 days. We are not used to file return statement in 30 years also. You know that. There are a lot of cases when I joined in the office, all 20 years, 30 years cases. You see, our good aim is, we don't want to give shock to the person who is filing the case. His grandson will know the fate of the case. In good intention only we are dragging the cases. Right? But government is mistaking us. So what happened? They used the word section 148 read with order 8 rule 1. It says a return statement shall be filed within a period of 30 days, shall be filed within a period of 30 days, extendable up to 90 days. Now Supreme Court says this shall should be read as may, because no consequence is provided for non-filing. Right? Leave this. Coming to Mukherjee versus Mukherjee, a division bench of Calcutta High Court. This is in connection with section 14 subsection 1 of Hindu Marriage Act. Mukherjee versus Mukherjee, section 14 of the Hindu Marriage Act. What does it say? No person shall file a dissolution of marriage within a period of 1 year from the date of marriage. You know that. So, if unfortunately you get married, 1 year you should suffer. Even if you find that you cannot get along with this, law says, my dear, you please enjoy it at least for 1 year. No person shall present a petition for divorce within a year of 1 year. It says further, however, if the petitioner makes out a case of exceptional depravity and hardship, he can file an application for divorce. This was interpreted by the division bench of Calcutta, and it says this shall is not shall, it is may, because no consequence follows. Right? 2019, what has happened? in Messrs SCG Infra Construction Limited, 2019, Messrs SCG Constructions Infra Limited, the provisions of Commercial Court Act came before the Honorable Supreme Court. Why we went to Supreme Court? We thought Supreme Court said Section 148, Order 8, Rule 1 is what? Order 8, Rule 1 and Section 148, what did Supreme Court say in Salem Bar Association case? Directory. Thinking that we went happily to Supreme Court, now Commercial Court Act also, Supreme Court will say, filing of written statement within 120 days is not mandatory. Supreme Court said, Order 8, Rule 10 of Commercial Court Act, that is CPC, is not discretionary, it is mandatory, because it says a written statement shall not be filed by the defendant beyond a period of 120 days, and court shall not receive it after that. Now the tale contains two stings. What are they? Party himself cannot file it after 120 days. Court also cannot receive. Okay. I think it is 7 o'clock. It is time, because it will take a long time for you all to go. I hope that Vivek Reddy sir will call me after some time. We can continue thereafter. We are stopping it by Section 193. So we have got 531. It will take another 5 hours. Okay. Tomorrow I am taking classes for some other persons. Right? In your state. I have given my number, no? You can text me. And I thank my senior, Mrs. Vrinda Mohan, who has taught me law. Right? All credit goes to her. If at all I have bluffed anything, it is Chandru's product. Any good thing that has happened, it is because of my senior who has taught me law. I just love all your patience. Right? The courage to learn and the passion to learn. I love you all. Thank you so much. Yes. Yes, Chief. You ask Vivek Reddy sir's junior here, Mr. Rajan. He is the better person to answer this question. When it will be continued? I am ready to give appointment at any time, sir. Catch him once again.
Yes, sir. I discuss municipality, arrange the next item.
Yes. Thank you. Thank you so much. Yes, sir.
ಥ್ಯಾಂಕ್ ಯು. ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಆಗಮಿಸಿದ ನಮ್ಮ ಬೆಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಎಲ್ಲ ಸದಸ್ಯರಿಗೂ ಥ್ಯಾಂಕ್ ಯು. ಈ ದಿನ ಮದ್ರಾಸಿಂದ ಬಂದು ನಮ್ಮ ಈ ಬೆಳಿಗ್ಗೆಯಿಂದ ಸಂಜೆ 7 ಗಂಟೆ ಗಂಟ ನಮ್ಮ ಅಸೋಸಿಯೇಷನ್ ಕರೆಗೆ ಹೋಗೊಟ್ಟು ನಮ್ಮ ಸಂಘಕ್ಕೆ ಬಂದು ಉಪನ್ಯಾಸ ನೀಡಿದ ಚಂದ್ರು ಸರ್ ಅವರಿಗೆ ನಮ್ಮ ಸಂಘದ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನು ಹೇಳ್ತೇವೆ.